To interfere with the award. Relief has been declined.
May it please, my lords. My lords, I beg to mention item number 14, my lords. My lords, I'm praying for 2 weeks accommodation, my lords. Mr. P.N. Goswami is indisposed, my lords.
Item number
14, my lords, with the consent of the other side.
no, but let it be called up, then we'll see.
Because he was required to obtain certain instructions, my lords. He could not do so, my lords, because he recently underwent a surgery, my lord.
But that's all right, we'll
Very well.
accommodate. Let
Very
the
well.
matter be called up.
Very well, my lords. Deeply appreciated.
My lord, one matter I have filed yesterday is a analogous matter is coming up on 23rd. So this matter may come up.
What is it?
My lord, this we have challenged an appointment under quo warranto. My lord, a person do not have the qualification. He has been appointed as a principal of a higher secondary school. So some urgency is there.
School appointment, are you sure this is the bench?
It's a PSU matter, my lord. PSU, I think the roster, as per roster, it is before this honorable court.
All right. Yes.
Obliged.
May it please your lordship. My lord, I am praying for listing of one pending matter where notice has been issued. Similar matters have been disposed of by this honorable court, my lord. May I pray this matter may take any date next week, your lordship. Maybe this point.
But I beg to mention item 15 and 16, my lord. The conducting counsel, Mr. A.R. Saivildar, is having some difficulty today, my lord. Any
These are very old matters, 2012 cases.
any day, but tomorrow.
No, sorry, rejected. We'll see when the matter is called up.
No, I'm praying for listing up 2 old matters, pending matters, for orders.
What order?
For orders, for listing
What's the order you want?
for listing in orders column, my lord.
What is the order you want?
Well, these are for applications for appointment.
What is the order you want?
My lord, the
They are rejected.
service has been completed, my lord. So
You can't even say what order you want. You want the matters to be listed for orders.
my lord,
What order do you
service
want?
has been completed, my lord. That is what.
Next week, next week.
Item number 3, Lord. So this matter is in fact heard in part by Honorable Mr. Justice Soumitra Swagia, Lord. So inadvertently released before Lordship today.
Item C, you write, it is submitted at the bar by Mr. D. Das, learned counsel for the petitioner, that this matter is part heard before another bench, bracket, Justice Soumitra Swagia, bracket, close. And therefore, this writ petition be listed before the appropriate bench. Register to verify and do the needful for listing the matter before the appropriate bench.
So can it be day after tomorrow, Lord?
So that will not.
Yeah, please, Lordship. Lordship, by taking consent from the other side, I beg to mention item number 24, Lordship. My senior will not able to do the matter due to his personal difficulty, Lordship. Lordship may kindly adjourn the matter for today.
This is a 2018 matter.
Yes, Lordship.
Why you want adjournment?
Lordship, my
We
senior.
are handling old cases with a lot of. You wait, we'll see. You wait, you'll be there when the matter is called up, we'll see. Yes.
May I please, the Lordship, I beg to mention for listing of a WPC matter on Friday, Lordship.
Listing for what?
WPC matter for
Listing.
motion stage.
Motion.
Yes, Lord.
What is the matter about?
Lordship, I was rejected for the post of GD in the CRPA for medical grounds. So for that, we are listing.
All right.
May I please, your lordship? Lordship, I beg to mention for listing of a WPC case number 710/2023 for admission hearing, your lordship. Can it be?
What is the urgency?
And as such, there is no urgency.
Don't mention there is no urgency. You wait for some time.
Absolutely.
Or you can request the registry to help you out.
Absolutely. Your
Yes.
lordship.
No, please, Lordship. Lordship, they are for listing a WBC, Lordship, for motion, Lordship.
When did you file it?
Yesterday, Lordship.
So it will come up.
Lordship, there's some urgency, Lordship, because Lordship, he will be retired on next February, Lordship. That's
What?
This matter is related to promotion, Lordship.
Friday.
And Lordship, Thursday.
Friday. Friday.
Then it will be Monday, Lordship. There's some difficulty on Friday, Lordship. Deeply obliged.
Next week.
May please, your lordship. I pray for listing of a writ matter for orders, lordship, on any date next week.
What order you want?
Lordship, in this matter, the service report has been awaited.
Next week, next week.
Much obliged, Lordship.
This matter, my senior used to appear. Today I have received verbal instruction to appear in this matter. Lordship will grant me 2 days time to file my wakalat.
What is the matter? Let us see.
Lordship, we have challenged the order passed by the Director General of Police, that is at page 36, Lordship, whereby he was encadered as civil defense operator, Lordship.
Page number?
Page 36 it starts.
Yes.
Lordship, the relevant portion will be at page 37, Lordship. The next second paragraph, Lordship. Under the circumstances stated above, Sri Basanta Datta PBX operator Civil Defense Office, Jorhat, deserved to be encadered in the grade of civil service of civil defense demonstrator / wireless operator, and he is encadered accordingly. His name will take place in the gradation list of civil defense demonstrator / wireless operator in accordance with his date of appointment and joining in service as PBX operator. Lordship, this order was passed against the rules, Lordship. Under the rules, Lordship, the government is only empowered to make any changes with regard to this changing of cadre, Lordship.
You are challenging this order.
Yes, Lordship.
Who are you?
I was appointed as civil defense wireless operator, Lordship. And
How are you aggrieved by this order?
Lordship, because of that, Lordship, he was granted seniority over and above me by encadering him, and subsequent promotions were also affected by this order, Lordship.
Where is the seniority list?
Seriously. Lordship, it's at page 38.
Yes.
Lordship, my name appears at serial number 4, and his the respondent number 3's name appeared serial number 1, Lordship. At that point of time, Lordship, there were 3 vacancies, and if he was not placed above me, Lordship, I would have been promoted at that point of time itself, Lordship. But then he was accommodated only for that purpose, and that is the reason why, Lordship, there was an observation made earlier that the promotion of the respondent number 3 shall be subject to the outcome of this case, Lordship.
All right. You place the facts, please.
Lordship.
Yes.
Lordship, may come to page 19 once, Lordship.
1 minute. So where is the order of appointment of the private respondent?
Lordship, that was the order as appointment as PBX operator. I have not annexed, but Lordship, the encadrement of the private respondent as wireless operator.
No, but unless you show the order, how do you say that he was appointed against an executor post?
Because, Lordship, there is a schedule appended to the rules, Lordship, wherein PBX operator is a separate cadre, Lordship.
No, but we don't know in what capacity he was appointed.
Lordship, herein it's been clearly reflected that he was serving as PBX operator, Lordship.
Right, but he was appointed as what?
PBX operator, Lordship.
Show us.
Lordship, page 36.
Yes,
I'm reading from the beginning itself, Lordship, that will clear. Peruse the application of Sri Bhakanta Das, PBX operator, Civil Defense Office, Jorhat, forwarded by the Additional Deputy Commissioner and in charge of Civil Defense, Jorhat, by letter number so and so dated 26/8/2010. The applicant was appointed as PBX operator by Directorate of CD and AG, Assam, order number so and so dated 1/11/1991, and he joined in service on 3/11/1991. And since then, he is continuing his service in the same status at the same station. So that was the appointment. May I read further, Lordship?
yes, yes.
From the departmental record, it is found that the applicant has not been so far encadered in any grade of service in the Civil Defense Organization of Assam. He is confirmed in the service of PBX operator by Directorate of Civil Defense and Home Guards, order number so and so dated 21/11/1997. The scale of pay of PBX operator was 1125.
Who is appearing for the respondents?
Lordship, the respondent number 3, one council was there, Lordship, but he, on the last 2-3 occasions, he did not appear. So, Lordship,
What
I
about
was-
1 and 2?
1 and 2, Lordship, the government appeared, Lordship.
Nobody is there for the government. Is there any reason? All right, yes.
Lordship. Lordship, may I continue reading that?
Yes, yes.
The scale of pay of both wireless operator slash demonstrator and PBS operator has been revised at rupees 5,200 to rupees 20,200 per month, plus allowances as per revision of pay in 2010. However, the grade pay of PBX operator is higher by rupees 100 only than the wireless operator slash demonstrator. I have gone through the provisions contained in the Civil Defense Non-Gazetted Service Rules 1991 and amended rules 1998. It is provided in the amended service rule 1998 as at amendment of rule 5 and amended rule 3 that in the principal rules in rule 5.1 in sub-rule 1 for clauses A and B, the following shall be substituted, namely recruitment to the cadres of civil defense demonstrator slash civil defense wireless operator shall be made by direct recruitment. For sub-rule 2, the following shall be substituted, namely notwithstanding anything contained herein before under sub-rule B, persons appointed to equivalent post in the civil defense department before commencement of these rules shall be treated to have been encadered in civil defense demonstrator and civil defense wireless operator. The higher grade of both PBX operator and the wireless operator slash demonstrator is assistant deputy controller junior, and there is no any further grade. As far as relevant rules and general principles of seniority is concerned, the relative seniority of all district recruits of direct recruits is determined by order of merit in which they are selected for such appointment on the recommendation of the selecting authority and the persons appointed as a result of an earlier selection being senior to those appointed as a result of the subsequent selection. The departmental records as revealed from the existing updated gradation list of demonstrator slash wireless operator of civil defense is that all the incumbents of the said list are appointees of different dates starting from 21/3/1994, whereas the applicant being the appointee of 1/11/1991 and he joined on 3/11/1991. Under the circumstances above, Sri Bhakanta Datta, PBX operator civil defense office, Jorhat deserved to be encadered in the grade of civil service of civil defense operator slash wireless operator, and he is encadered accordingly. His name will take place in the gradation list of civil defense demonstrator slash wireless operator in accordance with his date of appointment and joining in service as PBX operator. The application of Sri Bhakanta Datta PBX operator civil defense office Jorat is disposed of with the above order. So that was the order passed, Lordship.
So the rules are of 1998
Lordship,
and his appointment is of 1991.
Lordship.
But the rules itself says that any appointment made prior to the commencement of the rules, the person will be treated to have been encadred.
Lordship, but
I will challenge the rules.
no, the amendment was of 1998, but the rules were there in 1991. That provision was not changed during the amendment, Lordship.
No, but subsequently sub-rule B is there, no?
That they have quoted, but Lordship will kindly have a look at page 18, Lordship. Therein the rules are there, Lordship. Number 3. Class and cadre. Has your Lordship.
Yes.
Class and cadre, number 1, the service shall consist of the following class and cadres. Lordship, the post is at C and D, Lordship. That civil defense demonstrator and civil defense wireless operator. Both of them were separate cadres as on 1991. In 1998, both of those were clubbed together. And these rules are of 1991 itself, Lordship. And number 3, sub-rule 2 is relevant, Lordship. The service may include, PBX operator is not included here in Lordship, but it finds place in the schedule, Lordship, appended to these rules.
That is page?
The schedule, Lordship, will find at page 31, Lordship. Number 10, PBX operator is there.
So your client was appointed after the petitioner was appointed, after the private respondent was appointed, is it? What is the date of appointment of your client?
Lordship, 7/1/1995. Lordship, herein, that rule, page 18, rule 3, subclause 2, therein, Lordship, it has been provided at subsection B that any cadre or post laid down by the government to be included in a cadre or the service. So
the post of operator funds mentioned in the schedule,
Lordship,
PBX operator. So
but
the post is
Lordship,
recognized by the
that
service-
order was not passed by the government, Lordship. It was by the Director General of Police, Lordship. So that has been put to challenge.
No, but who says government has to pass the order? Where is the?
Here in the rules itself, that has been
Yes,
put.
yes, let us.
Rule 3, page 18, Lordship. Rule 3, subsection 2B. The service may include any number A, any post equivalent to a post in any of the cadres mentioned in sub-rule 1, and number B, any cadre or post laid down by government to be included in a cadre or the service. And C is also relevant, Lordship. The post equivalent to the post in the cadres of the service and the incumbents interchangeable as on the date of commencement of these rules as mentioned in Schedule 1. So the government is the authority, Lordship, to do this, Lordship, but then it was not done by the government. If it was to be done, Lordship.
That's all.
Lordship.
Come under the legs in court number 6.
Sorry, we can't wait. We'll mark him apart. Mark him.
Or
What kind-
he will come on a desk item.
No, but you are asking the court to wait.
My lord, the further timing for.
That's not possible.
And one more thing, Lordship. He was encouraged by this order, Lordship, and subsequently he was by that order itself, he was granted seniority, Lordship. So that could not have been done, Lordship. Immediately upon encountering him, Lordship,
No, what is your case in substance? You see, he was rightly encountered. That's what the court finds. So rest of it is all consequential.
Lordship, because it was to be done by the government or
No, that is your understanding. That's not the law.
the,
There is no
that-
such government. Why should the government pass an order for encountering the PBX operator? It will be done
Because
by
the
the
rules-
institutional.
rules itself provides, Lordship, and
Where is it?
that rule 3, sub-rule 2 B, Lordship.
That's your understanding. That doesn't mean what you're saying. That is your understanding or misunderstanding of the rules.
And Lordship,
There is nothing in the rule which says only the government can. Government means what? Is government defined in the rules? Government means the state government of Assam. Yes.
Lordship, that was what was there in the rules, Lordship. So that was what it was referred to, Lordship. In that order itself, Lordship, page 36, but that was interpreted in a different manner, Lordship.
All right. So anything else?
Lordship, if he was encadened at that point of time, Lordship, he could not have been granted seniority over me, Lordship, because Lordship, he have to serve that amount of time, Lordship, for in that cadre, Lordship, for seniority over and above me, Lordship. That was done wrongly, Lordship. Immediately by encountering him, he could not have been granted seniority, Lordship. And Lordship, that post of civil defense demonstrator and that civil defense wireless operator, the posts were different, Lordship, prior to 1998, and those were clubbed together only in 1998. Two cadres, Lordship, were clubbed, but then the post of PBX operator was not clubbed at that point of time. Lordship, if the rules do not provide that, and here in Lordship, the PBX operator finds place in Schedule 2 only, Lordship. The cadres do not find place in the definition.
So between you and the respondent number 3,
Lordship,
there are other persons also.
yes, Lordship.
Have you made them party here?
No, because I'm, Lordship, they were seniors, Lordship. I have no dispute with regard to their seniority, Lordship.
They are not complaining about the petitioner's seniority.
Might be, but Lordship, this order was passed wrongly, Lordship, and the grant of seniority was also given wrongly, Lordship. And if he would not have come in, Lordship, I would have been at serial number 3, and then my promotions would have been considered at that point of time itself, Lordship.
You are presently working as?
I am presently working as Lordship. Assistant Deputy Controller, Civil Defense Senior, Lordship.
And if the petitioner was, the respondent number 3 was not regularized, then you would have become what?
I would have been promoted. Deputy Controller, Lordship.
So respondent number 3 is presently deputy controller.
That instruction I do not have, Lordship.
Yes, Mr. Barua, what is your plan?
Lordship, I am reading from the affidavit of provision filed on behalf of the government, Lordship. May I just read out, Lordship, the appropriate part, Lordship. This deponent respect states that the petitioner appears to have misconceived the provisions of Assam Civil Defense Non-Gazetted Service Rules as amended 1998, and as such, he made an attempt to show that a post of civil defense demonstrator, wireless operator is a feeder post of assistant deputy controller civil defense. As a matter of fact, the post of Assistant Deputy Controller Civil Defense is a higher post than the post of Civil Defense Demonstrator, Wireless Operator, PBX Operator, and can be filled up either by direct recruitment or by way of promotion from the post of Civil Defense Demonstrator, Wireless Operator, PBX Operator, following the principle of seniority cum merit in the case of promotion. So then also regarding figuring the name of the respondent number 3 in the updated gradation list dated 6/10/2010 of Civil Defense Demonstrator, Wireless Operator, PBS Operator at the top, the competent authority has taken such step in accordance with the established service laws in as much as the respondent number 3 was recruited on the basis of select list prepared by the selection board duly constituted in the year 1991, and the petitioners and others were recruited in the post of wireless operator and civil defense demonstrator on the basis of select list prepared by the selection board constituted in 1994, and therefore the allegation made by the petitioner that having put the name of the respondent number 3 at serial number 1 of the said gradation list the allegation has been rejected illegally to serial number 4 from serial number 3, thus affecting prejudicially his chance of promotion is not tenable in the eye of law, Lordship. Then Lordship, para number 10, the deponent respectfully states that the allegation of the petitioner that the respondent authorities have sought to act in a high-handed, unreasonable is out and out absurd and ill-motived. The further allegation that the whole process smacked of malified and evident existence of element of favoritism and nepotism in favor of the respondent number 3 is misconception and of fact as well as law. The respondent authorities have not at all dealt with the issue mechanically without any application of mind, and high-handed and arbitrary action on the part of the respondent as alleged by the petitioner is wild, false, and unjust. There is no colorable excess of power of collateral purpose. Is Lordship disposing of today, Lordship? Lordship is disposing of today, Lordship?
Right now, not today. Why? You want to be done?
No, I
Yeah.
need to go through the matter some more. Like,
Oh,
because-
the old matters top of the list, no adjournment, except for medical emergency. Otherwise, why is it written top of the list? No adjournment.
Lordship.
Lordship, at paragraph 10, Lordship, I have, Lordship, at paragraph 10 of the repetition, Lordship, I have placed how rule 5(2) as amended, Lordship. Under that rule, Lordship, how that could not have been done, Lordship. Because, Lordship, equivalence, if any, was to be done with the assent of the governor, Lordship, but that was not the case here in Lordship. And in the reply, Lordship, my brain just placed what they have said.
Mr. Sharma, you are making all submissions, but without substantiating anything. You go on making whatever submission you like. That's not going to work. You have to show to the court that there was a requirement under the law to do it in a particular manner. But you are not doing it. You are just saying things which you think should suit you. That is not going to be taken note of by the court. Where is the requirement for governor to
Lordship, may kindly,
pass an order redressing the grievance of the petitioner? Where is the requirement?
rule 5(2), I may be allowed to read once, Lordship.
Yes, please.
That is at page 19, Lordship.
Hmm.
Method of recruitment. Recruitment to the service shall be made in the manner prescribed hereinafter. Recruitment to the cadre of wireless operators shall be made by direct recruitment. Number B, recruitment to the cadre of civil defense demonstrators shall be made on the basis of 50% direct recruitment from the civil defense volunteers and the balance 50% of promotion from the cadre of wireless operators. Recruitment to the cadre of civil defense instructor class 2 shall be made on the basis of 50% direct recruitment and balance 50% by promotion from the cadre of civil defense demonstrator. Recruitment to the cadre of civil defense instructor class 1 shall be made by promotion only. This is important. Number 2, notwithstanding anything contained herein before under sub-rule B of this rule, persons appointed in equivalent post in the civil defense department before the commencement of these rules shall be treated to have been encadred in civil defense demonstrator.
Right.
Lordship, the equivalent post, that thing with regard to that equivalent post, Lordship, it finds nowhere in the rules, Lordship. And subsequently, that thing was to be done by amending the rules or Lordship. But then that was not done, Lordship.
All right, that's all.
Lordship.
Now let me dictate the order.
Lordship.
Heard Mr. MP Sharma, Learned Counsel appearing for the writ petitioner. Also heard Mr. C.K.S. Baru, Government Advocate Assam, appearing for the respond number 1 and 2. None has appeared for the respond number 3. Full stop. By filing this writ petition, the speaking order dated 9/9/2010, passed by the Director General of Civil Defense and Commandant General of Home Guards, that is the respond number 2, has been put under challenge, inter alia contending that the interim order has been issued without proper authority of jurisdiction, and the same is in clear contravention of the relevant service rules, where the respond number 3 has been given undue seniority over the petitioner upon his absorption in the cadre of PBX operator. Stop. The facts of the case, in a nutshell, as appearing from the materials on record, are as follows. Stop. The respond number 3 was appointed as a PBX operator in the establishment of Director General from a civil defense and Commandant General Home Guards, pursuant whereto he had joined service in the year no, service on 1/11/1991. No, but the respondent number 3 was appointed on 1/11/1991. Person where to he had joined service on 3/11/1991 as a PBX operator. Stop. However, at the relevant point of time, the post of PBX operator was not, no, not like this, you're right. The pay scale of PBF operator and the nature of duty discharged by the said by the incumbent in the said post was for all practical purposes equivalent to the post of civil defense wireless operator and demonstrator. But at the relevant point of time, the post of PBX operator was not a cadre post under the relevant service rules. Full stop. As such, although the respondent number 3 had joined way back in 3/11/1991 as a PBX operator, due to the aforesaid incongruity, he was not given the benefit of seniority, whereas persons appointed after him, like the like the read petitioner herein, as wireless operator, were assigned seniority position in the gradation list. Aggrieved thereby, the petitioner had approached the authorities, ventilating his grievance in the matter. In the meantime, the service rules were amended by, in the meantime, the service rules, namely within quotes, Assam Civil Defense bracket non-gazetted bracket close service rules, 1991 unquote, were amended in the year 1998. The schedule to the amended rules did include the post of
Is 31 Lodge.
post of PBX operator with a pay scale of 1125 to 2215 per month. Taking note of the amended provisions of the rules and the grievance expressed by the respondent number 3, the respondent number 2 had passed the impugned order, not only treating him to be a part of the cadre service of PBX operator, but also assigning seniority to him over persons who were appointed after the respondent number 3. Full stop. Immediately thereafter, the relation list of wireless operators, civil defense demonstrators, and wireless operators, etc., were published, wherein the name of the respondent number 3 featured at serial number 1, whereas the petitioner's name appeared at serial number 4. Aggrieved thereby, the instant read petition has been filed. Mr. Sharma has argued that since the respondent number 3 was appointed against an ex-cadre post, he could not have been encadred by the impugned order, far less any seniority be, be given to him over and above the petitioner herein, who was all along holding a cadre post. First up, according to Mr. Sharma, regardless of the date of appointment, seniority in this case ought to be governed by the fact that the persons encadered, persons holding a cadre post must be recognized to be of higher seniority than those observed against ex-cadet post. First up, Mr. Sharma has further argued that it is only the governor of Assam who had the competence and jurisdiction to pass such an order and not the respondent number 2. Therefore, viewed from any angle, the impugned order is illegal and hence liable to be set aside.
One more submission, Lordship. Under Rule 5(2), Lordship, the posts have to be equivalent, Lordship, and in this case, Lordship, that equivalency is not provided under the rules, Lordship.
Acha. It is also the submission of Mr. Sharma that as per Rule 5(2), Rule 5(2) of the rules, that is the 1991 rules.
No, it was there in 1998 also, Lordship. It was not amended. Page 19.
As per the provisions of Rule 5 bracket 2 of the rules. The deemed encadrement can only be applied with regard to posts of equivalent nature, and therefore the impugned order is also bad on account of the fact that the post of PBX operator is not equivalent to that of
Wireless operator. Civil defense wireless operator.
civil defense wireless operator. First of all, the learned counsel for the petitioner has, however, clarified that the read petitioner is not assailing the appointment of the respondent number 3 in the post of EPBX, in the original post of EPBX operator, but only his seniority is under challenge in the read petition. First of all, Mr. C.K.S. Borua, learned government advocate Assam, on the other hand, has invited the attention of the court to the counter affidavit filed by the respondent number 3 to submit that the read petition is wholly misconceived in as much as the impugned order dated 9/9/2010 has been issued merely to give effect to the provisions of the rules and also to rectify a defect in the process of encadrement of the respondent number 3, first up, contending that the read petitioner is junior to the respondent number 3 and therefore cannot assail the seniority assigned to the respondent number 3. In this case, Mr. C.K.S. Borua has further contended that since the impugned order is in consonance with the relevant rules and considering the fact that the rules are not under challenge, no relief can be granted to the petitioner in this case. First up, I have considered the submissions and advanced at the bar and have also gone through the materials available on record. First up, as has been noted herein above, the read petitioner is not assailing the appointment of the respondent number 3 in the post of PBX operator, nor is the order of appointment a part of the record. Therefore, that aspect of the matter need not detain this court. Full stop. It is noticed from the materials available on record that even under the rules of 1991, the post of EPBX operator was included in the schedule.
Page 31.
At serial number 10. The rule of 1991 was amended in 1998. First up, No, before that you write. Uh, Rule 5 of the rules of 1991. No, Rule 5 of the rules of 1991 lays down the method of recruitment in the cadre of wireless operator, etc., which is reproduced here in below for ready reference. Page 19, or you will get it. Rule 5. Rule 3 of the rules of 1991 lays down the class and cadre wherein the post of civil defense demonstrator and civil defense wireless operator are mentioned. However, there is no mention of the post of PBX operator in Rule 3. Be that as it may, subsequently, by amending the rules of 1991 by the amended rules of 1998, the following provision has been inserted. I quote it from page 34. Double tick to double tick. It is by following the amended provisions of the rule that the impugn order dated 9/9/2010 has been passed by the respondent number 2. First of
PBX operator is not. PBX operator is not there in that amendment also.
you dictate the order.
No,
Then
sorry, I'm lost.
you take your seat. I am dismissing your writ petition. Mr. Sharma submits that since the post of PBX operator was not there in the earlier rules, hence this provision could not have been invoked by the respondent number 2 while passing the impugn order. First of, this court is unable to agree with such submission of the petitioner's counsel. Firstly, on account of the fact that the post of PBX operator did find mention in the schedule of the rules, although it was not included in Rule 3, full stop. Moreover, PBX operator was discharging duties which was more or less equivalent to that of civil defense wireless operator and demonstrator, carrying more or less equal pay scale. Therefore, if the respondents have found that PBX operator post was equivalent to the post of civil defense wireless operator and demonstrator, which post is included in Rule 3 of the rules of 1991, it cannot be said that such a conclusion is erroneous on the face of the record. Full stop. As a matter of fact, the respondent number 3, having been appointed way back in the year 1991 against a substantive post of PBX operator, he could not have been denied seniority in the cadre or subsequent promotion based on his seniority position. Therefore, this court is of the opinion that the challenge made in this writ petition is completely misconceived and does not deserve acceptance by this court. Full stop. It is also to be noted herein that there are 2 persons senior to the petitioner in the gradation list, but they have not been made parties in the writ petition, nor are those persons in any way aggrieved by the seniority position of the respondent number 3. Full stop. Under the circumstances, the challenge made in the writ petition is found to be not maintainable on such count as well. First off, finally, it may be noted herein that the impugned order was passed in the year 2010, and in the meantime, not only the respond number 3, but the petitioner has also received a number of promotions. Full stop. Therefore, unless there is very strong ground for this court to interfere with the encadrement of the petitioner, any order passed in the writ petition may have the potential of upsetting the departmental, upsetting the seniority position of the officials, and also the administrative setup of the department, which this court is reluctant to embark on. Full stop. For the reasons stated here and above, this court is the opinion that there is no merit in this writ petition. The same is accordingly dismissed. Parties to bear their own cost. Yes.
The Lordship will recall.
Lordship may kindly pass over the matter for the time being. Mr. D. Nath is appearing. He is on legs in court number 6, Lordship.
I had, if your Lordship recalls, I had completed my argument. It was for the government to address it. Lordship.
Then it will go to next week. Are you available next week? We'll have it on 30th then.
38.
Hmm.
Lordship.
Mal.
Freestyle share going on. For time being, sir.
You are available on 30th. 30th you are available. You are available on 30th.
Can it be taken today itself?
No, it has to be taken now. Otherwise, we'll adjourn it.
6 or less. It is only yes.
My lord, your lordship is proposing 30th, my lord.
Yes, yes.
Next.
Next one. Can it be on 2nd December? I mean, January, my lord?
2nd January.
Oh, no.
You want it
30th of-
today and then.
Oh, sorry. 30th of this month, my
Hmm.
lord. 2nd of December. Thank you, Paribane. My lord, 30th, my lord, I may not be here. That's the problem. My lord, say on 34th, my lord.
Of course, I am not available.
Let us see it on 30th, my lord, we shall see.
30th?
Interim has to be. Interim has to be.
But Mr. Aishwarya, senior counsel appearing for the petitioner, who has already concluded his arguments. Today, the matter was fixed for argument by the respondent side. However, accommodation has been sought on behalf of Mr. D. Nath, learned senior government advocate Assam, on the ground that he is on legs in another court. Mr. S. Dutta, learned senior counsel, has appeared for respond number
6.
6.
1 and 5.
Ms. M. Kutoki, learned counsel, is present for respond numbers 1 and 5. On the request of learned government advocate Assam, this matter is therefore directed to be listed again on 30th of November 2023 as a fixed part of matter. Interim order passed earlier to continue till then.
Published.
Item 5 to 9. 5 to 9.
May I please your lordship? Lordship, my senior is on the leg. He is in the another courtroom. The matter may be kindly passed over.
Lordship, in this matter, I am led by Senior Counsel Mr. P.K. Goswami, who is will be undergoing a cataract operation. Therefore, I would need some time. Yesterday I tried to circulate slips, but there was no NRC counsels. Therefore,
What is this matter about?
it's a release from their contractual service.
When do you want it?
Second week of December. Subject to convenience of the
Yes,
court.
Any objection? Mr. Goswami is undergoing cataract.
Yes, Lordship.
The council appearing for the writ petitioners in this batch of writ petitions have submitted that the senior counsel engaged in this case, Mr. P.K. Goswami, is undergoing a surgery of eye cataract, bracket cataract, as a result of which he is unable to come to court and conduct the hearing of this matter. In view of the above, a request has been made to defer the admission hearing of these writ petitions till the second week of December 2023. The prayer is not opposed by Ms. M. Bhattacharjee, Learned Government Advocate Assam, appearing for this case. In view of the above, let these writ petitions be listed again for admission hearing after the second week of December 2023.
Your Lordship, the interim may be.
Interim order passed earlier to continue till the next listing.
Obliged, Your Lordship.
Item 10, 11 as well.
10 to 10 super hour. Not to pay.
Item 10, only 10.
Yes.
Where the petitioner who is serving in the ITVP, challenging the initiation of a disciplinary, of a court of inquiry, my lord, on two grounds. One, that there was already a court of inquiry which was held, which had found him to be not guilty. The second ground is that, my lord, the CBC and the official orders of the respondents themselves debar holding of a court of inquiry or any other action on anonymous complaints. There is a judgment of this honorable court also that anonymous complaints should not be taken into account when a man is subjected to an inquiry. Now, the respondents have raised two answers to this. One, they disputed the jurisdiction of this honorable court since the court of inquiry will be held at Leh and I am posted at Guwahati where I have filed the writ petition. The second ground taken by the respondents are that the initial inquiry held was not a court of inquiry but was a inquiry. They simply say it's an inquiry. I was required to go through the records. I have gone through the records, my lord, which indicate that it was a court of inquiry where statement of witnesses were taken on oath, thus making it into a court of inquiry. Although the ITBP Act and rules do not anywhere provide for a court of inquiry as such. Well, if I'm allowed to go to the annexures, my lord.
So what you are arguing for disposal?
My lord, that was the understanding the respondents and petitioners had.
The lordship order is there that it should be disposed of at the admission stage.
All right, just take your seat for 2 minutes.
Madam.
The court of inquiry is a defined expression, obviously.
My lord,
What is the court of inquiry?
my lord, in the ITBP Act and rules, there is no definition of how a court of inquiry is to be held. What is a court of inquiry? I'm sorry, what is a preliminary inquiry? Court of inquiry per the Act is being held into any loss or anything that they want to find out a fact. That is a court of inquiry, which for the ITBP Act they try to show. Is that it is a court of inquiry which can go into any to find out in any fact finding inquiry is a court of inquiry which is done in a official manner. The convening or the board is convened, there is a presiding officer, witnesses are called, statements are taken on oath, cross-examination opportunities given, and thereafter the court of inquiry report is submitted, the findings are submitted, to which the petitioner is also entitled to all the copies if there is anything against him. That is what a
So
court
it
of
is
inquiry
almost,
is.
it's a quasi judicial.
Yes, and on the basis of those findings, the disciplinary authority can even go to the extent of taking a decision if it is not, if the petitioner is not available for holding a, otherwise the charges are framed and he is only given the.
So in
opportunity to-
2020, notice was issued.
2020, Mala, notice was issued, and in 2020.
Where is it? Let us see.
Mala, that notice, I'm sorry, Mala, notice was issued to me while I was posted in Guwahati, but I did not report there. I did not participate in that court of inquiry. They held it behind my back. The report of the court of inquiry, Lordship will find it page 18.
Page
18, my lord. Just, my lord, to emphasize that page 22, if Lordship has the vernacular part, at the last paragraph, paragraph 3, what the presiding officer says at page 22, last paragraph, अतः उपरोक्त संदर्भ सूचना व कर्मी गवाहों के बयान आपके कार्य में अग्रिम कार्यवाही हेतु प्रेषित किया जाए न्यायिक जांच, Lordship will find न्यायिक जांच की प्रतियां आपके कार्यालय को पुनः प्रेषित की जाती है. So this is what they call a court of inquiry in Hindi. They call it a न्यायिक जांच. Now, if we have page 18 for a moment, the report which was submitted, kindly refer to your letter number so and so by which the detailed inquiry report submitted in with regard to the allegations received by anonymous letter against Sri so and so of selling kerosene oil at Murgo outpost was rejected, showing some shortcomings. In the above reference, it is being informed that the clarification to the shortcoming is being forwarded as below. According to para 21 of the inquiry report, Constable Driver Anmol Kumar so and so had gone to Shok outpost on 14-2 by vehicle number CG so and so from Murgo OP with 810 personnel, and on 15-2-2020 he came back to Murgo outpost. The car diary of the vehicle and movement order was not attached as evidence. Therefore, the connected documents are attached and sent to your office for further action. 2. It has been directed to record the statement of the officers who were present during taking over of the charge by Head Constable Amit Kumar of Quartermaster of Murgo outpost. Sri so-and-so was available at the battalion headquarters during the month of February when the incident happened as per the order of Commandant 5 Battalion. When Sri so-and-so of 5 Battalion against whom the anonymous complaint had come, had upon being told verbally to give his statement, said that he should first be given a copy of the anonymous letter first, then he would give a statement. As per CVC guideline and standing order, no action is called for in case of anonymous complaint. Inspector Suchit Kumar Roy was transferred to 34 Battalion on 12/10/20. With regard to the statement, observation on the statement of Head Constable Ranjan has not been recorded. It is informed that the personnel was relieved on transfer. With regard to the observation that Head Constable Amit Kumar in his evidences stated that on 14-20 he had taken 10 personnel from Murga outpost whose names were given at answer to the question number 8. It is clarified that the statement of the Constable Jagjit Sampa, Padma Dasi and Deep Saha are recorded and attached to this letter. It is also informed that Constable G.D. Anish has been relieved on 12/10/2020 to 1st Battalion. Constable K. Mohan has been relieved on 12/10/20 to join at 33 Battalion. And according to movement order, Dayanand has moved from Murgo to Shok, whereas Dharmender was not posted at all at the battalion. With regard to the observation in the inquiry report that while according to most witnesses due to heavy snowfall in winter, the vehicles used to move after putting chain on their wheels and with difficulty could carry 10-12 barrels of kerosene oil. Constable G.D. Patil Sandeep has stated that 20 to 25 barrels of kerosene oil used to come. It is stated that the statement is made out of ignorance that 20 to 25 barrels of kerosene oil could be carried at a time in a vehicle. Since nearly all the other witnesses have stated that during February, the vehicles used to move with chains on their tires and could carry 10 to 15 barrels kerosene with difficulty. Here also an attempt was made to see whether 25 empty barrels of kerosene oil could be loaded in a vehicle. And it was found that firstly, so many barrels could not be fitted into the vehicle. And secondly, it is not possible that 10 to 15 Jawans and their luggage could be accommodated along with so many barrels of kerosene oil to that too at a time when there is maximum snowfall at the outpost in the month of February and there is every risk of the vehicle skidding in the snow. Moreover, all movements remain literally stalled. Myself being the commandant personally inspected the area of Alimore and Hanuman Road, and it has been found that in Leh the vehicle capacity is reduced by 20 to 25%. With regard to the observation that the enquiry report force number so and so in answer to question number 2 and force number so and so Rajendra Singh of 5th Battalion in answer to question number 6 has stated that 10 to 15 barrels of kerosene oil could arrive in a month. It is stated that the witness have clearly stated that 10 to 15 barrels arrived in a month, but I do not have personal knowledge about it. Moreover, in each witness has given similar evidence. Therefore, from the evidence, it is clear that the allegations leveled in the anonymous letter are totally baseless. Therefore, the aforesaid information and statements of witnesses sent for further action. Thereafter, Lordship will find that at page
So
20
this was a report sent by the commandant to the DIG.
to the DIG as a, if Lordship will have at the end of the, at page 22 at the end, it is Commandant Staff, Pithasin Adhikari, that is the presiding officer, and where the signature is there, my lord.
Page number
22. And my lord, this Siddharth Kumar, Senani staff, that means commandant staff, Pithasin Adhikari, that means the presiding officer. And he refers to the entire inquiry as Nyayik Janch. At the last paragraph, at the last sentence of the page 22. Para number 3, अतः उपरोक्त अनुसार सूचना व कार्मिक गवाह के बयान आपके कार्यालय में अग्रिम
No, page 18 to 20 is the translation of
translation version. Yes, madam. I am reading the vernacular version just to show that what the original records show.
So that's right. So this commandant was asked to conduct an inquiry.
And their records which they have given to me also a copy. That also shows.
And then he conducted the inquiry taking into account the statement of the
witnesses and everything was done.
Then this is the report he forwards to the
Yes,
DIG.
madam.
Then what happens?
This report does not hold me guilty. Things settle down for till 2020.
No, what order has been passed on this report?
My lord, that order is on the records. I was never given a copy.
What order has been passed on this report? 31/3/2021.
Lordship, some clarification was sought for because the authority.
Do you have the records?
Yes, Lordship.
Show me from the record.
Yes, Lordship. Lordship, I have the scan copy, original copy. May I just outside?
তাতে on legs করে হ্যাঁ তাতে তো on legs আছে in time to continue করে যদি ডেট দিয়ে
পয়সাটি The records are not ready.
Records are ready, Lordship, but so many flakes, that is why.
Acha, you continue, Mr. Majumdar.
My lord.
By the time
There-
letter.
Thereafter, my lord,
Hmm.
I was posted at Guwahati here.
Hmm.
And at page 23, my lord, my the second in command of my battalion gives me a letter dated 21/3/2023 at page 23
Hmm.
that there is a court of inquiry and I am being requested to attend the court of inquiry. Page 24 is what follows, my lord. Of the same date, 21/3. I'm sorry, my lord. This the copy was given to me on 27/3, containing a letter dated 21/3/2023, which is at page 24. Here, my lord, the presiding officer says, sir, kindly refer to the order number 21 dated 12/1/2023 issued by the Inspector General Northwestern Frontier Headquarters constituting a court of inquiry to inquire into the theft of misappropriation of 25 barrels of kerosene oil from 5 Battalion at Murgo Outpost. In the inquiry, some doubtful facts have arisen for which the presiding officer has deemed it fit, Lordship will find, to cross-examine the below-mentioned officers on 25/3/2023 and their presence is necessary. It is to be informed that taking in view the gravity of the matter, statements will not be recorded over video conferencing and as per directions of Director General, court of inquiry is to be completed as soon as possible. If any officer does not give his consent to the appointed date, then the report of court of inquiry will be submitted by 31/3/2023. The first man is me, my lord, in the table. So what the presiding officer of this particular court of inquiry, which was convened, Lordship will find on the first line by order number 21 dated 12/3/2023. This is a new court of inquiry which is now being convened, where he goes on to say the court of inquiry has deemed it fit to cross-examine the below mentioned officer. First paragraph, last two lines. And this is not a vernacular, this is not a translated copy, my lord. This is the order which they have passed, saying that the presiding officer of the court of inquiry has deemed it fit to cross-examine the below mentioned officer. My lord, the mindset of the court of inquiry now, when I am being called to a de novo court of inquiry for the first time to cross-examine me because already evidences of other people have been taken. He says, in the inquiry, some doubt.
Mr. Majumdar, you see, there is one issue here.
My lord.
This communication at page 19.
My lord, yes.
Or rather 18.
Yes, my lord.
This is the impression of the commandant.
The presiding officer of the then court of inquiry.
Right. So we will have to see how this has been dealt with.
Yes.
What is the order passed on this? Can you please pick it up? Then we'll see the record.
Yes. Lordship, some clarification was sought for that not satisfied with the report of the presiding officer, the higher authorities. Then another person was appointed to conduct the inquiry, Lordship. A new presiding officer was. Then subsequently, this report was submitted, and on the basis of that report, the 12/3/2000.
So if the appointing or disciplinary authority was not satisfied with the report of the earlier presiding officer,
Lordship.
Is there any requirement under the law to hear the
yes.
person against whom
I'm
the
entitled to the copies of the entire court of inquiry, along with
Is there
everything.
any decision dealing with this?
But
aspect?
their rule says so. The court of inquiry rule says so, rule 173. It says so.
Till
That I'll
then,
be given every document.
Lordship, we have not found anyone guilty, Lordship. This is only to
That's
come.
not the point. Point is, you instituted an inquiry.
Lordship.
Then the presiding officer was appointed. He had examined witnesses. And after that, he has given his report.
Lordship.
His report may obviously indicates that, first of all, the charge is not proved. And he has also mentioned that under the CVC guidelines, no inquiry, no cognizance can be taken of any anonymous complaint. Now, if the authorities are not satisfied or happy with this report and goes and decides to go for another inquiry or appoint another inquiry officer, Is there any requirement under the law to hear the petitioner first and then take a decision? Is the only question I'm putting to you. Is there any requirement under the law? What is that law?
That judgment I have not brought today, but if the inquiry of, if the
No,
disciplinary
without the
authority-
judgment, I'll not proceed further. That is the question here. If there is a requirement under the law, we'll set aside the whole thing. And we'll ask your officers to first hear him. You have to follow the law.
Lordship,
You're not above the law.
Lordship.
So you appoint your own officer, your own presiding officer, ask him to carry out an inquiry. He does so. He examines witnesses, takes note of the facts, and he finds that this allegation is absurd. It is not only incorrect, but it is absurd. And he also says that this anonymous complaint could not have been acted upon. You have to give strong reasons why you differ. Otherwise, the process goes.
Lordship, he is relying on a document that is of 31/3/21, Lordship, but this is prior to that, Lordship.
5th December. Let us come prepared, Mr. Majumdar.
I'll bring all the documents.
If this level of preparation, is not-
I'll bring the.
you also come prepared. I had Mr. R. Mangal, Learned Counsel for the petitioner, also had Ms. B. Sharma, Learned CGC, appearing for the respondent. After hearing arguments of the parties at some length, this matter is directed to be listed again on 5th of December 2023 as a fixed item for further hearing. Parties to in the meantime. Now, the Learned Counsel for the parties to in the meantime. Verify the legal provisions involved in this process and address the court on the next.
There was an interim order which continued.
Interim order passed earlier to continue till 5/12/2023.
I'm obliged.
No, what is this case is very straightforward and simple. Number one, you have to show us what is the law under which this process was initiated. Then there is an inquiry report of the presiding officer appointed by you. You can't deny that. So he has given a report. The report can be divided into three broad parts. First part, he says, under the guidelines and rules, anonymous complaints could not have been acted upon. Second, he says, on examining witnesses, the allegations have been found to be untrue. Third, he says it's absurd. In February, with heavy snowfall in that area, even 15 barrels one cannot take in a vehicle. Where is the question of 20-25 barrels, which will not even fit into the vehicles? You have to give us strong and concrete evidence that these findings may not be correct. You have to place before the court evidence to show that no, in a snowfall area, 25 barrels is possible. Then even an anonymous complaint, the CVC guidelines permit it, and that there are some evidence which goes against the petitioner. This is number one. If that is not there, we'll quash it and with no liberty. If you can place those facts before the court, then the next question would be that could you have deferred and appointed a fresh inquiry without giving an opportunity of being heard to the petitioner? If you succeed in that, then also it will be quashed, but you may get a liberty to start the process afresh. But in the first case, you will not even get a liberty if they succeed. And if they don't succeed, then you can do whatever you are planning to do. So you have to come absolutely clear on this counts and address the court. That's all. What else is there in this case? 5th December. Yes, next matter.
Obligement.
May I please, Your Lordship? Item number 11, Lordship. Your Lordship, I have challenged the selection process for the post of MVI, Lordship, and appointment order, Lordship. Now, Your Lordship, I have applied for the post under the EWS category, Lordship. And after receiving the RTI, my name is not in the selection list, Your Lordship. And after receiving the RTI, what I got to know that I am the highest mark holder in the EWS category. Now, Lordship, there are 3 posts already appointed, Lordship, under EWS category, Lordship. 3 posts are reserved, Lordship. out of 3 posts, Lordship, 1 post has been reserved for women, Lordship, and other 2 posts has been already appointed, Lordship. Now, Lordship, I pray before this honorable court to file an IA, Lordship, to impede those other EWS employee, Lordship, candidate, Lordship, to proceed with the case, Lordship. I have to file an IA, Lordship, to impede the parties, Lordship.
I am item, mine is slightly different. Because if your lordships remember, the APSC came up with a IA that they want to declare result. And during that proceeding, my lord, it transpired that 4 of the petitioners out of the 6, my lord, they are selected. So we are awaiting our appointment only after determination of the initial issue, whether a degree will presuppose a diploma or not. That is the main issue involved in the writ petition. So, my lord, if my case can be separated and heard, my lord, because her case is she belongs
No, can be separated. Why is it tagged? Is there a judicial order?
Yes, my lord.
Is a court order. What is the date of the order?
24/5/23, the first case of item number 10. WPC number 2969.
Right, so let us first pass an order in her case, then we'll heard Ms. G. Bora, learned counsel appearing for the writ petitioner, also heard Mr. P.B. Datta, learned
3, 4 and 5, APSC.
standing counsel APSC appearing for respondent numbers 3, 4 and 5, and Ms. M.D. serially divided. Ms. M.D. Bora, learned
Standing Council Transport, my lord.
standing counsel Transport Department Assam appearing for 1 and 2.
My lord.
Anybody else? Achha,
No, my lord.
serially already. By referring to the materials on record, Ms. Bora submits that after receipt of RTI response from the authorities, it transpires that the writ petitioner had secured the highest mark amongst the candidates belonging to the EWS category and therefore could be entitled to an order of appointment to the post of MVI. However, since in the meantime, two amongst the 3 posts meant for reserve category candidates have already been filled up, and the other post is for women, she seeks leave of this court to file an application to implead the appointed candidates. The prayer is not opposed by learned counsel for the respondents. In view of the above, register to list this case after the IA is brought on record. In the other matter, let us see what is the issue here. What is the issue here?
My lord, here the issue is, my lord, initially they issued an advertisement in the month of October 2020, my lord, giving qualification that higher secondary HSSLC with 3 years diploma in automobile or mechanical engineering. That was the initial qualification given. My lord, there was a note saying that this qualification is the minimum qualification. My lord, we applied pursuant to that. The petitioners before your lordships are the degree holders. Thereafter, they issued a corrigendum, including the degree of automobile and mechanical engineering as one of the eligibility criteria. They are also fine. Then subsequently, they come up with a corrigendum, my lord, cancelling the earlier advertisement. Thereafter, they issued a new advertisement, including only diploma. At this stage, we will not approach this honorable court, and this honorable court was pleased to allow us to appear in the examination conducted by the APSC, and pursuant to that, my lord, out of the 6 petitioners, 4 were selected. They have got marks, my lord. So now the question is, the legal issue involved is whether acquiring of higher qualification presupposes acquiring of the lower qualification. Because admittedly, we are the degree holders. If your lordships kindly come to the first.
So 6 months has already elapsed.
Yes, on the last occasion, my lord, this honorable court was pleased to extend that select list till today, my lord. Then my humble prayer is that it can be heard.
If the respondents finds any inconvenience in implementing, then it's all right. If it's not otherwise inconvenient to the respondents, if this can be heard separately, then this
The
four
issue is
person.
different here. There it is EWS. Here the question is whether their qualification can be treated as one under the advertisement or not.
Lordship.
Rest
But-
of it is.
But in the other writ petition, the now petitioner is implemented all the selected candidate then. All the selected candidate, Lordship, their prayer is that they are implementing all the selected candidate.
But in
only the
this writ
EWS.
petition, selected candidate is not implemented.
Not implemented, my lord.
Lord, we approached at the time when we were debarred from appearing in the examination, my lord. And there is no requirement as of now because
That's not
two will
required.
go, my lord,
Why
four are
should he
there
implement?
only.
Why should he implement?
And 4 posts were
The
directed to
lordship
be
may heard this
vacant.
matter because their prayer is regarding the qualification. In our Matar Vehicle Act, it is the diploma holders is eligible for that post.
And they are BE.
They are the
So what is the
graduate.
problem if BE comes? You know how many master's degree holders are in grade 4 in this high court?
My lord. We don't have any issues, lordship. May kindly have take up this matter another date, my lord.
Not today.
We have to
Day
go to
after
some.
tomorrow.
Day after tomorrow. Alright, good night. Dada. Dada.
Thursday, I don't.
Mr. Eskeda, Learned Counsel for the petitioner submits that the issue involved in the petition is completely different from that in item 11. And therefore, this petition be taken up, this petition be segregated and taken up independently. Ms. M.D. Bora, Learned Standing Counsel, Transport Department, Assam, and Mr. So-and-so for APSC are present and do not have any objection if the prayer is allowed. In view of the above, registry to segregate item 12 from item 11 and list the matter separately for admission hearing as a fixed item day after tomorrow. Give the date.
Can it be tomorrow or 28th, Lordship, if my learned opinion? And
Day after tomorrow, hearing day.
28 then.
28.
And list the matter again on 28 11/2023 as a fixed item.
My lord.
In view of the urgency involved in this matter, an attempt would be made to dispose of the writ petition at this stage of admission hearing. Interim order passed earlier to continue till then.
My lord. Okay, my lord.
Please, your lordship, while this is an IA for correction of my lord, typographical mistake in the order dated 9/10/2023, page 11, my lord.
What is the mistake?
That means mistake is, my lord, it should be respondent number 4. Circle officer is respondent number 4. And it is typed as respondent number 5, my lord. At page 11, in two places, one in the 4th sentence and 5th sentence. And in page 12 also, it is reflected as
Heard Ms.
respondent
L.B.
number
Chaudhary,
5.
Learned Counsel for the applicant, also heard Mr. J. Henry, Learned SC Revenue Department, Assam, appearing for the opposite parties.
Number
These
one.
Huh?
1.
Appearing for the opposite party, number 1. None has appeared for the remaining opposite parties. These are you appearing?
Yes.
Mr. D. Nath, Learned Senior Government Advocate, Assam, is present on
2 to 4.
opposite party numbers 2 to
2, 3, 4, 5, 5.
2 to 5.
Two to five.
This IA has been filed with a prayer to correct a typographical error occurring in the order dated 9/10/2023 passed by this court in WPC number 223/2023. Ms. Chaudhary submits that the circle officer of Nagaon Sadar, the circle officer of Nagaon Sadar Revenue Circle is respondent number 4, but he has been erroneously referred to as within quotes respondent number 5 in the order dated 9/10/2023, as a result of which some impediments have occurred in the course of implementation of the said order. First up, the Learned Counsel for the opposite parties have not opposed the submission made by the applicant's counsel. I also find from the materials on record that the circle officer Nagaon Sadar is respond number 4 and not respond number 5 as indicated in the order to stop. Therefore, the circle officer Nagaon Sadar shall be read as respond number 4 in the order dated 9/10/2023 with the clarification and correction.
And
28th
of February. 202.
Mm, 1 minute.
Yeah.
Yes. So what has happened?
Thereafter, the TEVA details, they have deposited the area pension and other benefits to the petitioner's accounts up to a certain limit. They have deducted 7,25,000 on account of the penal rent for the house that he occupied from the date of his retirement till till the date they have deducted till now. My lord, that part having been paid, there was a suggestion from both the petitioner's side and the respondent side had to some extent agreed also. There was a submission made that if he is taken to be retired from the date of order of this honorable court, keeping him notionally in service for this period without giving him the back wages, then they were agreeable to that. That would also be agreeable to the petitioner, my lord, provided that if the entire disciplinary proceeding is set aside, then the penal rent which has been, my lord, deducted, he would be entitled to retain the quota, therefore the penal rent would not arise. Even the respondents had given a short, my lord, submission where that was included, that they would make a request not to deduct the penal rent. In case he is given that financial benefit end of the day, he can go in and settle his life, my lord. If there's, as I met the petitioner, little scope for him to come back on duty, he continues. So my lord, that is where it stands as of today. That 7,25,000, if it is not deducted, and I had given a judgment passed by Lordships, my lord. It was there, copy them, Narendra Singh judgment, 2783 of 2018. Lordship had decided on 28/6/2023, the Narendra Singh judgment, my lord, is on record. Their Lordships at paragraph 25 had decided the issue which was reflected on 28th of February. At page 12, paragraph 25.
Para number?
25.
25.
This brings us to the final issue on the question of relief that can be granted to the petitioner at this stage. Mr. So-and-so has paid for reinstatement of the petitioner with full back wages. However, fact remains that pursuant to the order dated so-and-so, petitioner has been out of service. At this point of time, it is not known whether he is a fit mental or physical condition to rejoin the force. Moreover, it appears from the materials on record that the petitioner is nearly 53 years old as on date. Therefore, having regard to the peculiar facts of the case, court is not inclined to issue any direction for reinstatement of the petitioner after a lapse of more than 13 years since he was sent on compulsory retirement. At the same time, since it has been held that the impugned order so suffers from infirmity leading to setting aside of the same, petitioner cannot be denied the fruits of his success in this writ petition. As such, for the ends of justice and by balancing the equities, hereby provided that the petitioner shall be notionally treated to be in service till the date of this judgment. Accordingly, pensionary benefits of the petitioner be recomputed, whereafter arrear pension be released after adjusting the pension, if any, already paid to the petitioner as per impugned order dated so and so. In other words, by virtue of this order, the petitioner shall be deemed to have retired from service with effect from today, that is 28/6/2003. However, keeping in mind the self principle of no, therefore back wages is denied. Well, although I am informed that this has been taken up in appeal by the petitioner, there is no final orders passed by the court, my lord. Petitioner, my lord, to my instruction, would be satisfied if he is given the enhanced pension, taking him to be in service till today with all the arrears, my lord, part of which has been paid by the respondents. Now, my lord, the merit of the case, my lord, which would require the setting aside of the order. That, my lord, if lordship permits, we argue today, or if it is fixed on another date, we argue on that.
What
But
is
the
your response?
only issue.
My lord, we have already issued the PPO also, my lord, and we have deducted 7 lakhs as a panel rent, my lord, since he occupied that quarter in Duliajan Oil Campus, my lord. That is my instruction, my lord. 7 lakhs has been deducted from his pensionary benefit, my lord.
No, that's correct, but is it possible for both the parties to come to a middle ground?
Yes, my lord.
But then you have to place it on record.
Because that panel rent has not been deposited with the oil. It has been only retained by the authorities in case the oil asks for it. They have not asked for it. They have only retained it with them. That is what the instruction of what that was.
He has retained the quarters since when?
My lord, from the date of his,
Date
from 2010.
Date of impugned order.
Impugned order.
Date of impugned order.
That is 14/9/2010, my lord, I have retained the quarter.
Just a second. 14/9/2010.
My lord, yes, that is the date the commandant had compulsorily retired me.
Oil India is a party here.
My
No,
lord,
my lord.
oil is not a party.
Not
here,
a
my
party.
lord, because since they provide the security in the oil campuses itself, certain quarters are allotted by the oil to the CISF to.
So he is still occupying the panel.
No, but on 14/11, I think he
14/11,
14/11/2023, my lord, he vacated that.
He had to
year.
vacate it.
I have the instruction that he had vacated the year for fullness. Ano pa hapat mo sa report sa sila? Ano, ito naman, mapuno pa kasi. Kahit ko talaga ito sila. Ito naman kasi.
This panel rent is levied by whom? The
Penal rent should be in fact levied by the CISF, because I would be an unauthorized occupant, and the quarters being of the oil miner, they had to levy. It has not been levied upon me. The CISF had given me notices that you vacate this quarter because we need to give it to someone else. So now they have retained the penal rent calculate as would have been calculated by the oil, kept it with them. That if oil asks, we'll give it to them. Our oil has not asked till date. Because they kept it in the miscellaneous fund, otherwise it would have been paid to the oil once it was recovered from my money.
In our submission also, we stated that, my lord, then we may request oil Duliajan to waive all of the penal rent for his unauthorized occupants of the family quarter. Here, oil is not the party, my lord. Here, oil is not the party, my lord.
In case my proceeding, the disciplinary proceedings are set aside, then my lord, the occupation at least Had it not been issued to me on the first place, my lord, what Dipali Kundu Survasa had said, my lord, that it will go be relayed back to the time FD5 was never terminated from service. Although Dipali Kundu Survasa had given all the arrears of pay and everything back, I am not demanding that. All my prayer is, my lord, that if I am held to be in notional unit service, then my occupancy of that particular quarter will not be an unauthorized occupancy. And therefore, the penal rent would not align. Whatever they had to take as a rent, what they take as a rent, notional amount, that, my lord, can always be deducted. There is no difficulty.
Then we have to hear the matter then. We'll fix it in January. Because you have got your money now.
He has got some money, he has vacated the quarter. After giving me
Take down,
the
I heard Mr. R. Majumdar, Learned Counsel appearing for the writ petition. Also heard Ms. A. Gayan, Learned CGC appearing for the respondents. It has been brought to the notice of this court that in terms of the order dated 28/2/2023, the respondents have deposited the arrear pension as well as all other dues payable to the petitioner. However, a sum of rupees 7,25,000 has been retained from the payable dues of the writ petitioner on the ground that the same may have to be utilized for payment of penal rent of the quarter of the Oil India Limited, which was occupied by the petitioner with effect from 14/9/2010 till 14/11/2023. Mr. Majumdar submits that the OIL has not raised any bill for penal rent of the quarter. Moreover, if the petitioner succeeds in establishing that the disciplinary proceeding is illegal, then in that event, he cannot be treated to have been removed from service with effect from 14/9/2010. In such an eventuality, there would be no occasion for realizing a penal rent. Full stop. Ms. Gayan, Learned CGC, on the other hand, submits that the question of release of the penal rent to the petitioner would depend on the outcome of the writ petition, and therefore this matter be now posted for final hearing. After taking note of the submission of Learned Counsel for both the sides, this writ petition is directed to be listed for hearing in the first week of January 2024. The matter would now be taken up for disposal on merit. The writ petition will now be taken up for disposal on merit.
I'm obliged.
Please, Your Lordship. Lordship, in the morning is a prayer.
Yes, what has happened?
He had a surgery, Your Lordship.
Sorry?
Mr. Goswami, he's appearing in this case. Your
That's
Lordship.
correct,
Yes.
but
My lord, perhaps, my lord, on the last date, my lord, a submission was made by my senior that the agency concerned who is to supply that arm, prosthetic arm, with the department will demonstrate, held a demonstration. My lord, as regards that demonstration has not happened until now, my lord. And we, in the meantime, my lord, Mr. Goswami also fell sick, had to undergo a surgery. So when he's recovering, my lord, grant us some time, we'll expedite this process time.
I'm appearing on behalf of Mr. P. Mahanta, Your Lordship.
beyond that, anything else you want to say?
Sorry, Your Lordship.
Beyond that.
No, Your Lordship.
The petitioner is represented by the counsel, Miss
Miss C. Das, Your Lordship.
C. Das. Mr. D. Gogoi, Learned Standing Counsel, Forest Department.
PHE.
PHE Department, as well as Mr. B. Chaudhary, Learned SC. And who's for the health? Standing Counsel, APDCL has submitted that in terms of the order dated 26/9/2023, the concerned company was required to give a demonstration of the prosthetic limb, but the said process could not materialize due to the sudden ailment of Mr. P. N. Goswami, Learned Additional AG Assam, who is supervising the matter. First up, it is submitted that Mr. Goswami has undergone a surgery and is presently in the process of recovery. Soon after he assumes office after recovery, the matter will be expedited. Similar is the stand of Mr. R. Gogoi, learned standing
Teacher.
council,
He is
PhD.
with me, my lord.
Actually, both of you.
Oh, yes,
So then
thanks.
R. Gogoi not required. R.S. Ronghan for ASC and Miss M. Devi, learned government advocate Assam. In view of the above and taking note of the submissions made by learned counsel for the parties, let this matter be listed again in the first week of January 2024, so as to enable the learned departmental council to place on record the progress made in the matter in the meantime.
My lord, I make a mention in the morning, my lord, on behalf of Mr. A.R. Thavinder, my lord. So,
but these are very old matters.
At 2, my lord, I have informed him. Because he is not in court right now, my lord. He will be reaching at by 2, my lord.
What is this matter about?
Lordship, thing is that their praise for absorption in the government lordship. There was some repetition pending, which will ultimately be disposed of directly us to absorb them. Accordingly, we have done it, lordship. It is in our affidavit. Now they came up with another thing. So what about pension? So we have received instruction, lordship. They are getting the pension, lordship. I have honor to state that the petitioner, the Thomas, was retired on 31st/5/2022, and he has been granted provisional pension since 22 to till date, lordship. So, in fact, on the last date, lordship.
So how many petitioners are there here?
And here only, lordship.
Two petitioners. One
Is Thomas Boda. Yes, it's Bokanta Boda. It's also same, lordship. The second one. Bokanta Boda, lordship.
Then we'll close it.
At 2, my lord, because I have no idea regarding. He will be coming, my lord.
How about this? The provision. And because he's also getting another one, the Bokanta Roy is also getting pension lordship. Pursuant to the cabinet decision held on cabinet meeting, so the government of Assam pleased to allow proportionate pension and other admissional pensionary benefit to the ex-servicemen who had retired Assam Police Board organization under.
But this writ petition is with a prayer to reinstate him service.
That we have done, lordship. That we have done, reinstated him.
And you say that from where?
From our affidavit, lordship.
You ask your senior, what is the matter? And before rising, if this is the last matter, I'll take it up and pass order. You can't ask the court to wait. Why is your senior not in the court?
No, he is not my senior, my lord. He is just informed. He had some
We'll
personal
dismiss it for
difficulty
default.
in the
We'll
morning.
dismiss it for default then.
So I.
Matters, when the matters are in the court, the lawyers have to be present. So I'll call it up as last 2 items. You can do whatever you feel like. Otherwise, we'll close the matters. Yes.
17, 18, 19, 15, 21.
Lordship will only take up one item, item number 21. Only 21.
Number
114.
one and four.
11.
What are these matters about?
Yes, Your Lordship, this pertains to interstate seniority. In the interstate seniority in the forest rangers, Your Lordship, in the forest department. But the issue here is, Lordship, is it is seniority, yes. But the main issue, Your Lordship, hinges on 3 pages. The first issue is that there was an advertisement for 18 posts. And that advertisement had carried out certain terms and conditions as to how a graduate will be inducted, the process for induction. The 18 candidates were appointed Thereafter, 17 other candidates were also appointed without following due process of law. Now, those 17 candidates have stolen a march over me. That is the crux of the matter. It is a seniority matter, yes, but the entry of all the incumbents before your lordship.
Right, just 1 minute.
Yes.
You are appearing for all the petitioners
Yes,
in all these eight petitions.
yes,
They were appointed as what?
as forest ranger, your lordship, forest ranger, grade 1, forest ranger.
No, at a like to.
Forest Rangers grade 1.
Yes,
Which year?
year 1989, your lordship. 29/7 to be precise, 29/7, 1989.
Yes.
There were
then-
18 candidates.
No, I'll disturb you for a moment. Item number 19, my lord. KN Chaudhary is the petition. Senior counsel.
Item 19.
Item
Okay,
19,
yes,
yes, he is the petitioner. And in other party matters, my lord, he is the respondent.
Okay. Where is Mr. Chaudhary? Mr. Chaudhary is present?
He is on legs, perhaps he's he's on the way.
What? Yes. If I may continue.
Yes, yes.
Yes. Your lordship will kindly come to page 35, your lordship. There are not many annexures to go through. The file is 35, your lordship.
Not many extras. You are unhappy about it.
No. The issue is only few annexes. That the file looks a little voluminous, your lordship. Page 35, your lordship. Page 35.
Yes.
Yes. Pursuant to the advertisement, your lordship, there were 18 candidates who were selected to undergo a certain training at the Forest Rangers College in Kurseong. Your lordship, petitioner number 1's name features in serial number 5. Your lordship has gotten that?
These are parted matters.
No.
My lord, to be very honest, my lord, these matters were heard at length. But my lord, nothing was noted, my lord.
Heard by which bench?
So it is code 13, my lord.
Civil bench 3, your lordship, on different occasions.
We argued, my lord, records were perused.
If I may continue, your lordship, yes. Serial number 5 and serial number 9, your lordship, are the petitioners before your lordship.
Yes.
These are the 18 selected candidates, your lordship, pursuant to the advertisement.
So
Thereafter,
5 and 9 are the petitioners.
Yes.
This is petition.
yes, yes.
And the others are?
Others are also item number 18, 19, and 21, the same set of petitioners. Item number 17, there are a certain more number of petitioners. Most of them have retired also. But
But have you made a chart?
yes. I've made a chart paper. If I
Yes.
can continue. Your lordship will see at page 37 for a moment, your lordship, the next annexure, page 37. Now, since they could not be deputed to undergo their training at Kurseong, they were deputed at various forest ranges in the state of Assam. Your lordship sees that Hattugaon division, Kachugaon division, Lakhimpur division, Dorong East division, field inspector, Tiger Project, Borpeta Road. Your lordship has seen that.
Yes.
The petitioner's name also features there out of the 18 that your lordship just went through. Thereafter, page 38. Page 38 is the representation which has been preferred by my learned senior's client, stating that they were not appointed when the selection process concluded. And since they are educated, unemployed youth of the state, they need to be inducted. Page number 38. Page number 39 is a signatory. It's a typed copy, your lordship. Serial number 1, serial number 4, they're all the private respondents before your lordship.
So they took part in the selection
They
process.
took part in the selection process.
But were unsuccessful.
Were unsuccessful. Initially, what had happened, your lordship, was that a larger pool of 40 recommended candidates were recommended. Thereafter, it was shortlisted to those 18 that your lordship had just seen. So the others were basically left out. So after a certain point in time, these individuals, they preferred a representation stating that we have participated in the process for that long and we were not we got into the fray. So we kindly be accepted, we kindly be absorbed. Thereafter, pursuant to that representation, at page 43 is their final inclusion. Page 43 is the final inclusion. Page 43 is the final inclusion, Your Lordship. Now, this correspondence for Your Lordship, it does not have APSC anywhere. Although the initial advertisement.
Your clients were selected by APSC.
Yes.
And what is it, page 43? What is this?
Page 43 is the later included 15 candidates who had preferred that representation before a minister.
And what is the recruitment process which was followed here?
The recruitment process, Your Lordship, I need to be fair. The records indicate that there are no service rules in the forest department. For the past 33 years, 35 years, there are no rules. So the entirety of the selection process was held under the advertisement which was published. The advertisement which was published. The advertisement, Your Lordship, is at page 19.
That is the advertisement through which you also,
yes,
your clients.
I participated, their clients participated, and finally there were 18 candidates. I was one of those 18. They were not.
How many posts were advertised?
18. 18 posts. Page 19, Your Lordship, it's there. So that is where the case hinges, Your Lordship. Now, there are two issues. The second issue gains more prominence here. The first issue is that whether the merit list, which was published of the 18 candidates, should that have been followed while granting promotion? Now, that issue takes a backseat because now what has happened is that the later included candidates, they have also stolen the march. So the relief that I'm seeking now before this Lordship is that I be given my promotion when the outside candidates be given the promotion. Now, a lot of.
But have they published any seniority list?
They have published a seniority list. Your Lordship, in fact, there are multiple seniority lists. The first cause arise, Your Lordship. Your Lordship would kindly see page 44. Page 44. Your Lordship has found that. Yes, page 44 is a draft gradation list.
So your clients are still in the rank of forest ranger?
No, I am ACF. And they are DFOs. They are one rank higher.
DCF.
They're one rank higher than me. But they gained the march. I have to be fair. What had happened was the advertisement laid down certain criteria that depending upon your performance in the graduation course, your rank will be determined. But that was determined along with those outside candidates also. Now, thereafter, when I graduated from the college, the first two gradation list, I was the senior most. I was senior to the juniors, those candidates were below me. Thereafter, in 2006, for the first time, I was overtaken by my juniors, and that was a draft gradation list which was not published. My first cause of action arose in the year 2012, when the promotion was given to my juniors and outside candidates, and that is when I approached this Honorable Court. All the other matters, Your Lordship, are follow-ups of that matter. Now they have gained a march. They are senior to me. I have a few years left. I have 1 year left, 1.5 years left. The other petitioners have retired. That is the only prayer that I'm seeking now. Maybe not shake the entire seniority list. That may be asking a little too much. But since they have enjoyed the fruits of their promotion, let them have it. But at least me be also promoted.
No, not that kind of.
Then,
is not possible in service.
Then I have all the records for Your Lordship to probably impress upon Your Lordship.
Let them also have against which post?
No, they are already promoted. They are already promoted in the first post, which is ACF.
If you succeed, their promotion will be set aside.
Then Your Lordship will set aside. Then Your Lordship will set aside the promotion. That is what my prayer is.
All the petitioners are still in service.
No, there's only one petitioner who is still in service. He is about to retire in the next 1.5 years. He's an ACF.
What is his name?
Kuhol Puar Deka. He's the petition number 1. He's the petition number 1, Your Lordship.
Others have all retired.
Yes.
So what relief they want now?
Notional benefits, Your Lordship. If I'm accorded my promotion from a certain post from a certain time, it may even ensure that I would be promoted to a different post because I had gotten my promotion at a later stage, which I ought to have been preferred before the outside entrance at least, if not the.
What is the criteria of promotion?
The criteria of promotion, Your Lordship, that is it's. Your Lordship would see. Since they do not have any service rules, the promotion which was the inter se seniority, Your Lordship.
Subject to appointment letter.
Page 28, Your Lordship. Page 27 rather, page 27, Your Lordship will come to page 27. These are the terms and conditions which have been laid down.
27 of
Page 27 of the petition. Your Lordship has gotten page 27. Your Lordship, subclause C. So these are the terms and conditions that have been laid down as to how a student is going to be marked depending on his performance in the subjects in the college after selection. It continues, Your Lordship.
No, what do you want to show from page 27?
27, Your Lordship, there are certain criteria which have been laid down that in case of failure of a student selected from departmental candidate in more than 2 subjects in the first year examination or more than 1 subject in final examination, supplementary examination thereof. Page 28 also, Your Lordship. Page 28. Yes, page 28. Clause 15. A candidate should also note that in the event of his being selected for the training, he'll have to fulfill preceding conditions, and non-fulfillment of any of them will make him liable to refund all the amount drawn by him and so and so. 16A. A candidate should note in the event of his being selected and sent up for training, he should adapt himself to hard and vigorous life of forest, and that when appointed in service on successful completion of training, he cannot be expected to be posted in a place where urban facilities are available. The candidate so selected will be required to join the college on the 1st of May, so and so. On successful completion of 2 years course at Kurseong, the student will be awarded by the college authorities either the higher standard certificate in forestry or the lower standard certificate in forestry and will return to Assam to join duty. Those students who are awarded the higher standard certificate in forestry will be appointed as forest ranger in the scale of pay admissible to forest ranger, and those who are awarded the lower standard certificate in forestry will be appointed as deputy ranger in the scale of pay admissible to deputy rangers. So these are the criteria which are laid down. In fact, my appointment order in 1989 also states that subject to finalization of the draft service rules. That was in 1989. 34 years have passed, there are no service rules. But even if there are service rules, that will have no bearing on this case. In fact, if these conditions ought to have been implemented, these conditions ought to have been implemented amongst the 18 candidates. Now, what had happened is that those 15 candidates at a later point in time, after having not made the list of 18 candidates, they were included by way of a representation. And then eventually, subsequent gradation list, they took their rank as higher than mine. And I was not aggrieved till they did not steal a march over. I was only aggrieved, my first instance of being grievously.
So your argument is that their entry into service is through a process
which is not sanctioned. In fact, state of UP versus Rakibuddin also, Your Lordship, in 1970s UP judicial municipal case, this Honorable Apex Court has stated that even if a high-powered committee has framed rules without adhering to the subject rules and conditions in place, they cannot be legitimized. Here, there are no committee was in place. There were no rules. The rules are as before, Your Lordship. These are the rules. Those 15 candidates came at a later point in time. Till the first 2 gradation lists, they were junior to me and I did not have any reason for complaint. The first instance where this stole a march over me, I approached this Honorable Court.
17.
I might not have been well versed with my subjects in my college, and that is the fact that the records might indicate otherwise also. But the fact that I ought to have been compared with the 18 candidates, not 35. That is my case. That is my case. There is no submission.
I'll start with item number 17, my lord, 6723 of 2013. We have filed an affidavit. So, my lord, that cause is espousing that the private respondents entered later. That is no, my lord, he is not challenging that entry, my lord. That has sailed, my lord. And that apart, my lord, we have filed affidavits where, my lord, the appointment, he himself stated, the petition states So the person who, my lord, secures more marks in my lord's training, my lord, will be accorded seniority, my lords. So, and I also have a,
See, Mr. Gogoi,
my lords,
the petitioner, Mr. Sharma, has already argued that they were concerned about their future, their service. So till the time the private respondents were treated not as senior to them, they did not have any occasion to challenge that. But it is only when the private respondents were assigned seniority and then promotion, that is when their shoes started pinching, and that is when they challenged it. Now, if otherwise they would have approached the courts, the plea would have been that they are not affected. Why are they? This is not a public interest litigation. But when the moment they challenge it on being affected, they will be entitled to take any ground, which will take the ground which dates back to their initial appointment.
my lords.
Because the reason is simple. You will argue that they have not challenged. So their challenge will date back to the original entry.
So keeping that in closet for a moment, my lord. This is an argument, my lord, modified. Earlier, this case was that APSC in the merit list, we are on top. No doubt they have entered later. They are below us in the merit list. Let us be granted seniority over them, which allegedly, purportedly, we have not done. However, my lord, the appointment orders are very clear. The person who secures more marks in my lord's this forest course, the 2 years course, undergone course, he will be given seniority, my lords. Because, my lords,
That is correct. He is
Yes.
agreeing to that.
yes,
But you can't bring in another group of people who are not homogeneous with this, because this 18 is the group you have selected
my lords,
pursuant to a selection
my
process,
lords, my lords,
APSC held process.
my lords,
They were the applicants. They competed on merit.
my lords.
They underwent the selection process.
My lords, these,
Then you took out a select list, so they are the selected candidates. Correct.
yes.
The
But that-
others say that we tried, we failed, so appoint us. That is,
there
why
were-
you have appointed is another matter. But how can you give them
My lord,
seniority?
they were inducted in the course, my lord. They were the given course. They joined the forest course in the same year, on the same date. Same year, same date, my lord.
Nothing. Their entire process is illegal.
But that is a different aspect, my lord. He has to,
That is
there's
the
a
only
fresh course of
aspect,
action, my
yeah.
lord.
That is the
There's
only
a fresh course of action because, my lord, recruitment and appointment are two different issues. My lord, they were recruited by PSC, but appointment order comes only into effect when they were, my lord, selected and given a job. And that was subject to, my lord, successful completion of a course.
No, but is it the correct process? Somebody makes an application that we appeared, we failed, appoint us. Is that the correct
This
process?
is not on a challenge, my lord. Whole, my lord, he started with that basically the case is about seniority. And how that seniority is fixed, my lord?
Oh, you are not understood. That's what I say.
My lords,
Earlier, he did not challenge because he had no reasons to
my
challenge.
lords, my lords.
He is not going to go around with a torchlight and see what illegality is happening. But the moment it has affected them, now they will challenge. So that challenge will even date back to all grounds they could have taken. That's what I'm saying.
No, my lord, that is, my lord, some oral submission is coming, my lords. My lord, only a paragraph is indicating of that point. But my lord, they are not aggrieved by that. They say, my lord, earlier the case was totally different. They say in a merit list, we are on the top, give us the seniority. Now, my lord, as I have stated, my lord, when this matter started, my lord, we have argued, my lord, this point was argued. And my lord, on that day, my lord, the petitioner had backtracked. Now, my lord, today, again, it's coming, my lord. That aspect was dealt with, my lord. That aspect was totally dealt with, my lord. And even our affidavit, my lord, if my lord takes up, my lord, it's filed by the undersecretary. That has been also justified. We are solely, seniority was given on the basis of a marks code. That was, my lord, never challenged. And that apart, my lords, and for that promotion, my lords, stay with it. Right. So only one petitioner remains. I'm afraid, my lord, I have to accept his submission. If, my lord, it's in.
No, but you have not done it.
So my lord, there was an impression because draft rules were under circulation, my lords. Because finalization of that rules, if somebody is promoted, my lords, because a batch
So,
of
Mr.
promotion has to be
Gogoi,
created.
you can argue for half a day, whole day, or
Yes.
rest of the week. Their entry is illegal. When we'll hold it.
Well, that was
They,
not
they
this-
can't, they could not have entered like this. We failed to appoint us. What kind of an entry is this? But all right, you have given it, you have given it. These things are 3 decades old. We are not going into it.
Exactly.
But
my
how
point.
can you deny them the benefit? The people who came in through the correct procedure, you cannot deny them the
No, my
benefit.
lord, that we are not denying, but my lord, they have to
Give them promotions with retrospective effect.
No, my lords, again, my lord, it sails back to that point. From that question, my lord, admitting, no, my lord, assuming, not
Done
admitting.
it to save the embarrassment for the department.
My lord, what
If the
happened
judgment
at
is
point,
written.
my lord, we cannot
there
turn
is a
back the
strong
clock
observation.
and my lord, give him, my lord, his promotion was based, seniority was based on marks scored on the, my lords, on the basis of the.
Correct, but that score of marks could not have been applied to those candidates who have come in through the backdoor channel. We will hold that here. That only could have been applied amongst those first 18. They are a different class. The remaining 17 is a different class.
My
You
lords.
can't club them together.
My lords.
You do whatever you want to do with the 17. But 18 channel is
15.
different because they came through the proper process. That's the only matter here, nothing else.
My lord, that, however, that remains, my lord, that one who, my lord, seniority is granted, my lord, because again, my lord, it will go back to that point wherein, my lord, that I understand, my lord, that entry was not challenged. Now it is again, this skeleton is out of the cupboard, my lord. But still that, my lord, the person, my lord, who scored in a course is ought to be had given seniority, my lord.
What is the point in going round and round and round?
Yes, my lords.
Already we have discussed that
We have
that
discussed
criteria
on
will
this.
be applicable only for people who are in the same class,
My lords.
not legal and illegal class. You can confuse it and say apply the criteria.
My only anxiety was there, my lord, because this calls for, in my humble submission, this calls a separate cause of action total altogether, my lord. Only he is submitting. My lord, Mr. Chaudhary is there, let him come, my lords. For the private
We'll
respondents.
close the matter before 1. He wants to come, he'll come.
Until that.
You have nothing to say. Once the court has taken up the hearing, I'm not going to adjourn it.
Yes, my lords. I am also, we have to wrap it up, my lords. It's 2000, from 2013 is going on.
Anybody is free to make arguments, but I'm not adjourning this matter. I'm so sorry. Hmm? I'll ask him, I'll call up Justice Sekha and ask him what he has submitted. What else can be done?
My senior submissions were based on what my learned.
No,
friend
no,
has-
these are not legitimate.
Yes, that is not it.
You want to argue? You argue.
But only anxiety is, if my lord now interferes with this might unsettle a few things. Since only one petitioner is there, my lords, my lord will hold what is legal. This should be in person, my lords. It should not be in going rem. Otherwise, this might unsettle a lot of things, my lords, because 30 years have passed.
Unsettle what?
My lords, if seniority list, my lords.
So others have all retired.
Yes, exactly. One
Probably
petitioner,
only a question on notional.
my lords.
What will it unsettle?
My lord, these other persons who are serving, my lord, the private respondents.
That's right. They remain wherever they are.
Exactly,
The
man.
court
They
is
might not
not
be pulled
interfering
on.
with their.
Well, they might not be touched, man. That's my anxiety.
So, Mr. Goswami, at 2, but I'll not adjourn it. I'm making it very clear.
My lords.
And please give the written submissions. Written submissions, give it. Who is on service, who is not, what is. You have not prepared a written.
No, I
submission.
prepared a list of recitals that your lordship had sought for. As to which petitioners are
And
there.
hand it over at 2. There comes Mr. Chaudhary.
Another legs in.
No, that is understandable. But point is we have to move on.
My lord, I can make my submission, my lord.
You can make it or you can make it at 2, whatever suits you.
I can do it, if your lordship permits, I can for 10-15 minutes, yes.
See, Mr. Chaudhary, let there be some clarity on what has transpired so far, so that you can, in a pinpointed manner. Original advertisement was for 18.
Yes.
APSC held a recruitment process, and the 18, which are the petitioners in the different petitions, minus your case, they were notified as the selected candidates. The criteria in that process was that the seniority will be on the basis of the marks scored.
In the training.
In the training, correct. Then subsequently, your client submitted a representation saying that we tried our best, we did not succeed, so please appoint us. And on the basis of that appointment, the 17 candidates were subsequently appointed. And they were also asked to undergo the training. And the petitioners, many of whom they could not make it to the training at the first instance. Thereafter, the seniority was decided on the basis of marks obtained in the training, in which they scored higher marks, your client scored higher marks, and that is how the whole prognosis went on. Now, his case is that your entry in the system is not as per a process recognized by law. Whatever has happened, I'm not challenging. But this criteria of marks obtained in the training program cannot be applied vis-a-vis the petitioners and the second batch of people. It can be applied inter se the group is another matter. But the entry of the 17 is purely fortuitous, here's the process of law, and even contrary to Article 16. So we have no problem with their entry. They have come in, let them be there. They have got promoted. We are not. But that criteria you could not have applied to put the petitioners who have come in through a legitimate channel at disadvantage. One argument raised by Mr. Gogoi is that they did not challenge the entry of the 17.
Precisely.
Yes. This is a tentative view the court has, which I'll request you to kindly address. See, when the 17 came in, they were not affected. They were not affected. Their grievance cropped up when seniority was determined and promotions were being given to the other group. Otherwise, in service matter, there can't be a PIL. There has to be a case only when they are
Every person alone can come.
So, I don't know if there is any decision. Prima facie, the court is on a legal point, on a purely legal point, regardless of who benefits. That in these kind of matters, where these people had no occasion to challenge it earlier, subsequently, if they challenge when there is a cause of action, they will be entitled to take all grounds, including the ground of legitimacy of appointment, if not for anything else, for the purpose of seeking a relief before the court. It may so happen that balancing equities and for equitable reasons, the court may not disturb anything. But for seeking a relief, that liberty has to be given to the petitioners. Otherwise, the whole process becomes meaningless.
No, my lord, that liberty lordships will give, provided there is a challenge. Where is the challenge? Where is challenge to our appointment? They are not agreed by my appointment.
Not agreed by your appointment.
No, they are not agreed by our appointment.
They are not agreed.
They are agreed by the fixation of seniority. No, my lord. There, I'll submit this way, my lord. Your lordship has sort of formed a tentative view that if the seniority is qua the same batch of people, then the marks obtained in training would be decisive. But vis-a-vis, the appointee who is beyond the advertised post, then in that case, there can be no parity. Therefore, that seniority will not come into play.
There is no homogeneity between the two groups.
No, my lord, with great respect, my lord, that may not be the correct position. For the simple reason, now what is their case? Let us see their pleadings and let us come to their prayer in the petitions, my lord. They never challenge if our appointments are, yes, my lord, in a 226 proceeding, lordship is not very fussy about, delay. Because there is nothing like delay in a 226 petition. Yes, at times, if there could be some latches, if there is an adequate explanation, then lordships will certainly entertain. Time is not irrelevant. What is relevant is the explanation which is forthcoming. In a given case, my lord, even 1 year delay could be fatal. In a given case, my lord, even 10 years delay, latches can also be condoned. It all depends upon the facts. Now here, if my appointment is not challenged, and this is an appointment of 1989, and 23, my lord, they are questioning my appointment. I think this is against all the Supreme Court judgments on the point.
Mr. Chaudhary, we are formulating a
No,
legal
what I'm
issue.
trying to say is, my lord,
He is not challenging your appointment for setting it aside.
if, no, my lord, if he is not appointing my challenge, no, if he is not challenging my appointment, he cannot, my lord, without challenging the parent action, can he question the consequential action?
No, he is saying you may be there in the service. And this is an argument I would request you to address the court.
Yes.
You may have a formidable
No,
argument.
my lord, what I find is, in Tilokchan Motichan, which is a case dot on the point, that's a constitution bench judgment. My lord, that judgment was authored by Justice Hidayatullah. There, this point cropped up. The Honorable Supreme Court says that what delay, in what manner it will affect a proceeding will depend upon the facts of each case. But a party seeking enforcement of fundamental right must approach the court at the earliest. Because the court exercising 220 jurisdiction or Article 32 jurisdiction will not examine belated and stale claims. For the simple reason, because of the delay, my lord, some right has accrued. And that right will not be disturbed unless some good reasons are forthcoming in the form of explanation.
How is the right of your client being disturbed? If they succeed, they will get notional benefit in terms of pay. What else? All of them have retired.
No, we're not retired.
One, except one, everybody is retired.
Only one petition.
That's all.
Yes.
So what is the right that your clients will suffer?
No, my lord, if today they are made senior, or as long as he gets this benefit, I am not there, my lord. Without disturbing my position, my lord, if he gets, I have got nothing to say.
That's all. The promotion has to be given notional benefit with effect from when the juniors were promoted.
Yes.
And in
No,
some-
now the moment the question comes, who is junior, then my lord, the seniority will come.
No. As a matter of, you see, if we treat the two batches, batch A and batch B, let's take it that way, 18 and 17. So out of these 18, only one is in service and others have retired. So assuming, please don't take it that the court has made up your mind.
No, I follow, man. No,
But the court is trying to project one point of view in a very focused manner and is always open to appreciating your arguments, which you are here to make. But to cut short the matter and come to the meat of the matter, that's why I'm pointing it out, that ultimately there will be two confronting or competing arguments. First argument from your side would be that right, wrong, forget it. They
No,
have
my
not
lord,
challenged.
no, my lord. Why I'm making this submission, my lord, I am taken by surprise when this argument is advanced. Because there is a discipline. Discipline is that you must make some pleadings. My lord, all throughout I have prepared my case on the basis that they are saying that it is not the training merit, it is the APSC merit which should be decisive. That is the case projected. I am taken by surprise to hear this argument, my lord.
No, this you can take it from a query from the court.
No, my lord. Because we came prepared to argue the case because their case is, it is the APSC merit list which should govern the seniority, not the merit position obtained in the training institute. Now the advertisement says.
No, that's what. Would you like a little time?
I think I would like to
fair
look back.
enough. See, the point is, whatever he has argued, he hardly argued for 5 minutes. But looking at the features and facts, this is an
No, my
area-
lord, before that, since your lordship has indicated that if some notional benefit is given to him without disturbing our, then I can have a word with our client also.
You have a word.
Our lordship
You
will
have-
call the matter sometimes in the next week.
What about Thursday?
Thursday, my lord, or Friday, my lord. As the both cases, no?
Both case is not an issue for Mr. Kiran Chaudhary.
Let it be on Tuesday.
You will always have both cases.
Tuesday next, my lord. All right, lordship will call it on Thursday. Keep it in the second half, my lord.
So let me formulate what are the issues. And this does not in any way preclude you from arguing your case.
Yes.
And the court has definitely not made up mind. But the points are like this. I remember I had heard this matter earlier sometime, so some thoughts were generated then and I recollected it when he stood up. See, broadly speaking, there are three areas where the matter hinges. Number one, the procedure followed for appointing the second batch, which is obviously not in accordance with law. But the question is, now at this point of time, or when they file the writ petitions, can they complain about the seniority merely because they have not assailed their appointments? That is one argument you would like to make. Please develop your argument on that. And in doing so, also kindly address that service matters, these are not PILs. This rule of locus is to be enforced very strictly. So if anybody, not them, anybody comes to the court saying that in future I may have a problem, the argument will be that this is an imaginary litigation. You come when the cause of action arises. And then he comes 20 years later, the argument will be that, why did you not assail it earlier? Both ways it is possible. So I am on only broad principles of law, not on what happens in this case, that will come later. So in these situations, if a person aggrieved comes after 10 years or 15 years and says that now my shoe is pinching, so therefore I have come, will he not be entitled to argue any matter which goes into the root of the matter? So that is an area, please address argument.
Yes.
You may or may not agree.
My lord, there my answer would be little knowledge which I have, my lord. It's not that lordship will non-suit him merely on the ground of latches. No. It will depend. But my lord, there has to be a good explanation for it. Why he had to approach late.
Agree.
If that inspires your lordship confidence, then certainly lordship will adjudicate.
Okay. Second aspect of the matter is, what is, even if they succeed, what is the relief the court is contemplating? Out of the 18, 17 have retired. If they succeed, they are only going to get notional benefits, which has got nothing to do with your clients.
No, it might affect me, my lord.
How?
Because if his seniority is to be notionally fixed, then he will be entitled to consequential
With
benefit.
effect from when the juniors were given promotion, that's all.
No, in that case, no. The moment lordship says that even he have come belatedly and that he and I do not belong to the same stream, therefore he will rank senior.
No.
The moment he ranks senior, all the consequences of being a senior will
He will
follow.
get it, but nothing has been taken away from you.
No, today I'm a divisional forest officer.
Right.
Tomorrow he might become a conservator of forest also.
Only
based
one
on-
person is there. Others have retired. They can't become anything.
No, I know. Anyway, my lord, I've got your lordship's point. I'll try to satisfy your lordships. I think this is a case in the absence of an explanation as to why there is a belated approach. Perhaps, my lord, the matter should not be, interfered with at this belated stage. That's the preponderance of the judicial view.
All right. So
Because
that
why
was-
I'm saying so, my lord, in the Supreme Court also, this point has been taken by Government
That's
of
correct.
India.
That's the point.
That's why I have made some
That's a
research,
valid-
my lord.
That's a valid
So I
argument.
have Tilok Chand is the first case. Then, my lord, there is one Ram Shankar Devdhar, and all these cases are there.
No, that's a valid and strong argument. That's a formidable argument. But I am putting into you
There
the
is
other
there is
point.
also an argument, my lord, though it may go against me. In our reference case, Supreme Court has formulated one point. When it comes to violation of Article 21
There is
and
no-
29, there should not be any delay. Delay should not come in the way. That is on 21 and 20.
That view has been expressed by this court also in some judgments. There is no latches or negligence in a matter involving fundamental right, enforcement of fundamental right.
In fact, my lord,
Legal rights, yes.
in fact, the moment there is violation of Article 13(2), then delay cannot be a factor because it is something which is stillborn. It's a bad thing.
That's right. Mr. Chaudhary, seeking a little assistance from you, I want to write a good judgment here without disturbing whatever is there. So kindly give me some legal inputs on this.
Yes.
Because
In that
this
case,
is
lots
happening-
will have it on Tuesday, not Thursday. Thursday, I'm slightly tied up.
Then it
Tuesday.
goes to next Thursday.
Okay,
Tuesday.
next Thursday, no problem. Next Thursday.
And you also do some research. Think beyond your client's interest
Yes,
only.
yes, absolutely. Your Lordship.
Let us streamline the law. What happens? Let's see.
Yes.
To what extent we can go. Mr. M. K. Sharma, Learned Counsel. is
M.
appearing-
Sharma.
M. Sharma, Learned Counsel. Appearing for the writ petitioners in items 17, 18, 20, and 21 has completed its arguments. Mr. K. N. Chaudhary, Learned Counsel, appearing for the writ petitioners in item 19 and the private respondents in rest of the cases has sought time till 30th of November 2023 to make his submissions. I have also heard Mr. D. Gogoi, Learned Standing Counsel, Forest Department, Assam, appearing for the departmental authorities. It was good, Mr. K. So you prepare a written note
Yes.
giving who is where, what is the issue.
Yes, Your Lordship.
And then we'll see. The question here is in these service matters, the devil crops up several years later. So what is the?
No, my lord, Lordship perhaps note that Rafiquddin's case, 88
That was
supplementary
pointed
one
out
SCC.
earlier only.
Rafiquddin is there where
State of UP was.
appointment was saved.
So they said no seniority.
No senior.
That was given to him last
Yes.
time, I believe.
Rafiquddin.
The High Place Committee.
And Rafiquddin was followed by our High Court. Actually, my lord, my learned friend perhaps has not apprised the facts. All throughout this tussle is going on within the department, my lord. Not that point which my learned friend is urging, but the point which should be the determining factor. The APSC merit list or the selection. In fact, there is a Supreme Court judgment, my lord, in case of Himachal Pradesh, where I have brought it, my lord, where it says it is the training seniority of the merit position in the training which will be determining factor. Anyway, there is a
Thank
slight.
God there is no law on delay by the courts.
Yes.
Otherwise,
Right.
there would have been, these are matters of.
No, my lord,
2013.
merely for a case, I will not make that extreme
No, no,
argument.
that's-
It all depends upon the facts of each case. And normally this provision should be construed liberally, my lord. As long as it supports furthers the cause of advancing fundamental right, that should be preferred.
May I please, Lordship? Lordship, I'm on behalf of my senior, Mr. S. Chaudhary, Lordship. Lordship, he is in bereavement, Lordship. He will come from Tinsukia tomorrow, Lordship. Lordship, may I kindly adjourn the matter today? for today
Your
only.
name, please.
Armethi.
Ms. Armethi, Learned Counsel, appearing for the petitioner, submit that her senior will be arguing counsel in this case, namely Mr. S. Chaudhary, has suffered a bereavement and therefore is unable to come to court today. On such ground, a prayer for adjournment of this matter for 3 weeks has been made. Mr. C.P.S. Burman, and the government advocate Assam is present and does not have any objection with the prayer is out. In view of the above, hearing of the matters comes adjourned, which accordingly.
Thank you, please.
Right, please, your lordship. Well, the lordship had asked for the records and perhaps the records have come. Now, may I just place a sequence of events that have taken place in the matter? 2009, September 2009, there was an advertisement for the post of Deputy Director of Tea Development. And that advertisement, your lordship will find it in Annexure 1, page 24 in the writ petition. The advertisement was for one post in the position of Deputy Director of Tea Development.
Annexure 1, page.
24.
Yes.
Now, the post was advertised and petitioner as well as the respondent number 5, they had participated. But the respondent number 5 emerged one of the successful candidates. He was placed at serial number 2 of the select panel. The select panel was drawn on 12th of April 2011, which is at page 27. Page 27, he was at serial number 2, the respondent number 5. And the present petitioner, actually, he came 5th, there being a difference of only 1 mark between respondent number 5 and the petitioner. In any case, the appointment was since it was a single post, so appointment was offered to the person at serial number 1, namely Mr. Anupam Das. and he had joined the post. Simultaneously, on 29th of June 2011, the respondent number 5 was offered the post of deputy director. That offer, your lordship will find at annexure 3, page 29. Anupam Das had joined on 6th of June 2011.
When did he join?
6th of June 2011. And thereafter, on 29th June, the offer was given to the respondent number 5.
Yes.
After this, the respondent number, after this offer came, then the respondent number 5 joined, but on 7th of July 2011, page 33, this offer was withdrawn because it was realized by the respondents that they were under a wrong impression that the vacancy position were more. That at page 33, your lordship will kindly see.
According to you, these are promotional vacancies.
Yes, according to me, he has been given given the appointment to a vacancy which would otherwise go to the promotion cadre and promoting cadre. They have maintained a stand that it is a direct recruitment post.
So if they succeed in their stand, then you don't have any case.
Still, I will have a case because this has been given without any advertisement of the post. After the first panel was prepared, there was a requirement of one post, one candidate, but they prepared a panel of 3 candidates. In any case, after the first person got the appointment, the panel was exhausted. Thereafter, if they had to make some appointment on a direct recruitment quota, there was a necessity of at least advertising the vacancies so that I could also compete in the parade.
That's not the law. The person who has been appointed was in serial number 2 of the panel.
Maybe.
If the vacancy was meant for being filled up by direct recruitment, then you may not have any case. Otherwise,
No, even if the vacancy was meant to be a direct recruitment, I will still have a case because law requires that the post should be filled up only after the post has been advertised and the equal chance of
that's
participation has
correct,
been
but
given.
how are you prejudiced? You have taken part in the selection
No, that part is already over. After the post was advertised and it was won. I participated, I lost. Understood. The matter stands at that stage only. If subsequent post arose and subsequently they wanted to make an appointment, there was a requirement of making an advertisement of that post. Because
according to you, the second vacancy arose subsequent to appointment of the candidate at the serial number 1.
yes, it is also everybody's case that ultimately a second lot of vacancies were created and therefore he was adjusted in one of those posts.
No, Mr. Datta, please look at what is being asked. The first point is, was the second post meant for direct recruitment or not? That is the first question. If it was not meant, then you will succeed in the writ petition in all probability because we have not yet argued. But if it is shown that that was a post which was also earmarked for direct recruitment under the rules or norms or circulars, whatever they follow, and they filled it up by operating the same panel, though only one post was advertised. There are judgments both ways. It's not that what you are saying is the gospel truth or the law. It's not that. There are decisions on both ways.
But the
Some
preponderant
cases, Supreme Court has said that you can't fill up more than vacancies advertised.
yes,
Those judgments, if I remember correctly, I'm giving you this feature so that you can pinpoint if
Yes,
you argue.
yes.
Otherwise, there's no point. Those are cases where people have complained that these vacancies which were not there at this, on the date of advertisement and subsequently arose, if you filled it up, that deprived us of a chance to participate.
That is exactly my point. In case they succeed in
But
establishing.
you participated in the selection process and your merit was below the person who was appointed. You wanted a second chance to improve. That's what your case.
Yes.
So though there is a gulf of difference between the two. In those judgments where you are relying, that was a case when people who became eligible did never get a chance to participate. But here is a case is you wanted a second chance to better your performance.
No, I slightly make a distinction here. My case is that if the moment the first appointment, the moment is the first candidate was appointed, the matter, the advertisement and the exercise that was undertaken pursuant thereto, that came to an end. It is not open for further operation in the future. Unless and until they say, yes, they can do so. Because the Supreme Court has said that only in exceptional circumstances and large public interest, it can be permitted. But this is a very rare occasion. The preponderance of opinion, subject to what your lordship will say.
Yes.
Preponderance of opinion is that once the list gets exhausted, no further appointment can be made from that list.
That you are correct. Ordinarily, that is the norm. that is
Yes.
to follow.
Now, if they are to make a case that there was a pressing need, and therefore this appointment had to be made, then the case would have been a different. My case would have stood on a different footing. The point is that, my lord, the moment the number of posts was the post advertised got filled up, subsequent posts came, and they mean to say that it is against those kind of posts. Now, if your lordship will look at the selection rules, recruitment rules, recruitment rule recognized 6 posts.
All right, so let us come to that. The advertisement was issued
Yes.
on,
The advertisement of it was September 2009.
yes, on that date, how many posts were there for promotion and how many for direct recruitment?
Total number of posts were 6, out of which 17% was earmarked for direct recruit.
17%.
Yes.
So what is
17%, it will roughly come to 2 posts. Because this comes in a fraction 1.7 or something, it will roughly come to 2.
All right, and where does one find it?
The recruitment rules at page 69. Page 70. Page 70. 79.
Hmm.
79 column 3. Total number 6. And the percentage your lordship will get next page, column 11. %83 by promotion, 17 by direct recruit. Now, what was obtaining the factual situation obtaining on 2011 was that there was already one direct recruit, Mr. Gognesh Sharma, holding 1 vacancy, and the second person to get the post of direct recruit was this Anupam Das, who got appointed in 2011. So on 2011, both the posts of direct recruits were filled up. Next lot of posts came on 25th of May 2011. And that next lot consisted of 4 posts. As per the affidavit in opposition filed by the respondent number 5, the next lot consisted of 4 posts. Your lordship will kindly come to page 106. Page 106 is the notification by which the posts were released.
Page 106.
106. Running page.
Yes, please. Yes.
Says serial 2, Deputy Director of Tea Development, 4 posts.
106 of which?
106, there I'm telling the running page of the brief. Otherwise, it will be on their affidavit, it will be page 11. Affidavit by respondent number 5, page 11.
Page 11, which para you are reading?
No, my lord, it's a notification from the government of
Page
India.
11 is a paragraph.
Page 11 to
Page 11 is a, contains paragraph 11 of affidavit filed by respondent number 5.
Page 11 of the affidavit in opposition filed by the respondent number 5.
That's right. That is 106.
106, yes.
That's right.
Serial number 2, Deputy Director of Tea Development.
That document is not here. There must be some.
It was আপনার affidavit.
Right, it could be page 108. Is it the letter dated 25/5/2011?
Yes, yes, 25/5/2000.
That's the there is some
More
some-
at the internal page 11.
there is some variance in the. There is some discrepancy in the.
Maybe, my lord, I am just.
All right, no problem.
25th of May.
Page 13.
Yeah, that's right. That's page 13, 108 serial.
So
number.
maybe 2 pages are missing in this copy that has been given to me. Anyway,
All right.
my lord, the number of posts released subsequently were 4. So this takes the total to
6,
6 plus 4, 10.
total 10.
So even if 17, they have also taken a stand that 2015 a separate amendment was made to the bylaws and the proportion was increased from 17 to 20. But
The 17% of 6 is not 2, Mr.
no,
It's
I am
one.
saying
It's
ignoring
hardly
the
one.
fact. I am saying ignoring the fractions. It can be at the most it can be 2. It can never be more than 2. Even if these 4 vacancies are taken into account. Suppose 6 plus 4, 10. It comes to 1.7. So rounded figure it can be 2. So on 2011 with the appointment of Anupam Das, both the vacancies of direct recruit were filled up. So there could not be a situation that the respondent number 5 got appointed.
As you say, somebody was already holding the post of.
Yes.
What
I
is
have-
his name? Is he a party here?
No, I have in my rejoinder affidavit, I have said he was holding the post from 2009, 15 July 2009. My reply affidavit, in my reply affidavit, I have mentioned it.
Which paragraph?
It will be page 83, but I'm not sure because the pages are little bit mismatching. It may be 85 now. Internal is second, more affidavit or second internal?
My reply, huh?
More reply. In my reply affidavit to the respondent number 5's, to the response of respondent number 5, there I have mentioned under paragraph 5.
Yes.
Subpara, as regards the statements made in paragraph 3E of the affidavit in opposition, the deponent begs to submit that the T board submitted as per prescribed percentage, 9 posts were required to be filled up by promotion and 2 by direct recruitment. That was their stand. However, it appears that board intentionally suppressed the fact of the direct recruitment of Sri Gognesh Sharma, Deputy Director of so-and-so on 15 July 2009. Accordingly, appointment of so-and-so to the post of TWR through direct recruitment exhausted the vacancy of 2 posts through direct recruitment. Therefore, office memorandum number so-and-so 410/2013 for appointment of Kamal Chandra Vaishya, that is respondent number 5, to the deputy post of Deputy Director Tea Development through direct recruitment is illegal. And I believe, my lord, the records will also support my stand. Because the appointment of Gognesh Sharma is not disputed. He resigned from the post in the year 2016. That is also on record. And with Anupam Das, it came to the quota of direct recruit was complete. So that is as far as the issue of direct recruitment quota seats are concerned. Now, essentially, if this has to be, he has to be accommodated, then naturally the post against which he can be accommodated is a post falling to the promoting cadre.
That you are correct.
That is the promoting cadre post. And in promoting cadre post, otherwise the feature is that the recruitment rule requires 5 years of residency period in the cadre of ADTD, that is Assistant Director of Tea Development, to become eligible for promotion to the post of Deputy Director. I became additional director, assistant director on 31st March 2009. and he became assistant director in the year 2011, 2 years after me.
And what is the criteria for promotion, even if it is given? Promotion?
Then by now, by this time, we are all at par eligible because it requires 5 years residency in the post of assistant
But
director.
your client is not a deputy director.
No. He was also aspiring for the post, being a senior candidate in the cadre.
Right.
Direct recruitment quota, he did not get it. And he came second in the select list, so he also did not get it in the first event. But somehow he was accommodated later, and that is the grievance with which the writ petition has been filed.
All right.
And so far as the now otherwise, as your lordship had said, that even if they succeed in establishing that this is a post for direct recruit quota, I have given the quota breakup, my lord. I don't think there will be any doubt on this count. But still, even in that case, my lord, there was still a requirement. That is my submission before your lordship. There was still a requirement that with the vacancy position should be notified so that I could also take a chance against that competition.
Fresh advertisement should have been.
Fresh advertisement should have been there.
So, do you have any authority in support of this proposition? That it's mandatory, no exception is permissible?
No, I do not say that no exception is permissible. I said, my lord, as the proposition goes, it can be relaxed only in exceptional and pressing circumstances. I have two
grounds
judgments.
to relax was not there.
No. There was no occasion for relaxing because the quota is itself filled up. If they wanted to fill up a
No,
vacancy,
if you succeed in your first limb, the second limb becomes irrelevant.
okay, yes. I have two judgments in my hand, my lord, but both the judgments say that the vacancies, appointments in excess of vacancy, excess of notified vacancy. There is one judgment, my lord, of this honorable court, which is part of your lordship brief, page 55. It starts from page 55, my lord. There, the honorable court tried to carve out a situation that it is not always an absolute proposition, that in no case it cannot be in excess of notified. That your lordship has perhaps seen. But subsequently, another judgment came from Supreme Court. Well, it was also a case from our High Court only, the APSC matter. In that APSC matter, my lord, what had happened, there were posts advertised were 27. The select list was drawn of 64. Government made 27 appointments, and there were few ad hoc appointees government wanted to regularize those ad hoc appointments. Then the persons who were in the select list below number 27, they came to court saying that instead of regularizing those ad hoc appointments,
The facts are well known.
yes. So in that case also, my lord, the
You
honorable
know the reason why the facts are well known. Do you have
And
the judgment?
interestingly, my lord, those were the candidates who participated in the APSC selection and failed. In whose paper
Do
Supreme
you have
Court?
the judgment?
Yes.
So do you know the reason why facts are well known?
Yes, yes. So in that case, my lord, the honorable Supreme Court said that no, regardless of the fact that you were in the extended select panel, no rights accrue to you. The vacancy number was, notified vacancies were 27. So that is.
No, that's all right. Mr. Datta, to be very candid in expressing the opinion, the court is interested in the first limb of your argument. And if that is established, then subject to what Mr. Chaudhary, Mr. KL may say, that matter may have a clinching bearing. Other aspect, you see, that will be in the realm of scrutiny depending on facts in
Yes.
each case.
Yes.
APSC, where number of vacancies involved, the public at large is interested. There the parameter will be something. In a matter of this nature, where mostly all of them are departmental candidates,
Department.
is it not?
Yes.
So you can't apply the same yardsticks. I hope the court is not required to write a judgment on that.
No, no.
But
That's why, my lord, I said
tentatively, that yardstick, I don't think will be applicable in this case.
that other
You have to succeed, and if you do so, you may succeed. To show that vacancy under the rules in the promotional quota was not available. If that is established, that's the end
no,
of
that's
the
why, my lord, I had shown the.
That's the end of the matter.
That's why, my lord, I
Apart
had-
from that,
Direct-
those judgments the ratio. It is the ratio of the decision that is applicable. Here you are all internal candidates, departmental candidates, except that your client gets a second chance to better his performance in the interview. There is no other element of public interest involved.
No, there is.
In this matter, but
no,
there was an element of public
No,
interest.
there is one aspect of Article 14 being violated.
Hmm.
Because if it is a public employee, since it is a public employment,
Hmm.
everyone must get an equal opportunity of competing for that particular post. Now you advertise one post, he is an SC candidate, I am also an SC candidate. Both of us, we fight for the post that was advertised, it was unreserved post. We both fight for
Mr.
it.
Datta, I'm sorry to point this out. Slightly on an academic tangent. You see, Article 14 and 16 in service matters will come when the treatment is discriminatory. When in the panel, one person gets 2 chances and another person gets 1 chance. These are circumstances where Article 14, 16, those ambits will come into play. You can't extend that argument of Article 16 in your facts on this point, because you are saying that because I should have got another chance.
No.
Everybody would have got another
Everybody
chance.
should have got another
Even
chance.
everybody should have got another chance. Nobody got it. No Article 16. No Article 14. No Article 16. Only thing is, if this was a matter which was a matter of recruitment in RAM, the public at large was interested, then the parameter would be very different. But this is a process amongst the departmental candidates. Only thing is the vacancies are different and the
One pointer, Miller.
yes.
It was a it was a recruitment process open to all. It was not limited to departmental
Correct.
candidates.
But you come in the picture as only a departmental candidate.
Yes, that's true.
You are not taking up the case for someone who
That's
was
true.
interested.
But since it's a selection process, intending to invite competition from one and all who are eligible.
That's totally, that can't be your case. You're not arguing a matter or taking up a case, you means your client. For others, for the society. You are here trying to seek your own right.
My right is that
if this was done, then others could have come. That can't be.
No.
Somebody else coming and saying that, why haven't you done it? I would have got a chance. The matter would be completely different.
I am saying that the moment they decide to fill up the post without making any advertisement or without inviting any competition, that infringes my right under Article 14.
How?
Because I am losing a chance of competing for that
The
post.
person who is appointed, he also got the same chance. Because you are below him, you are not losing out on anything. You are operating the same.
My lord,
levels.
perhaps, my lord, I am missing out on this aspect of the matter. The panel does not remain alive after the appointments are made.
Why? Where is it the law?
There is a definite guidelines on it.
Where is it? Where is it? Show us.
That your lordship will find at page 50.
Yes, 50.
50.
Yes.
Page 50.
Yes, please.
The period of validity of panels for posts in autonomous bodies recommended by screening committees. It has been brought to the notice of this department that ministries have been proposing appointments to posts in autonomous bodies based on recommendations which were made by selection committee more than a year back. This has also come to the notice of appointments committee of the cabinet, and the SEC has directed that the Department of Personnel and Training shall frame appropriate rules and instructions regarding the period of validity of such recommendations. The matter has accordingly been examined in this department. It will not be appropriate to make appointments to posts, particularly at senior levels, based on recommendations which could be treated as outdated if they are based on screening assessment of application received more than a year back. It is also necessary that administrative ministries departments take follow-up action to obtain the approval of the competent authority as soon as recommendations of the selection committees are available. It has therefore been decided that the period of validity of the panels recommended by the screening committee for appointments to posts in so-and-so may be restricted to a ceiling of 1 year. The date of commencement of validity of the panel will be the date on which the selection committee makes the recommendation.
So how does it help you, Mr. Datta?
It helps
This
me
is within
because
1 year.
No, it was before. It was.
Oh, the panel is dated 12th of April 2011. And his appointment was made when? June.
But it was cancelled thereafter. I am challenging.
That is
challenging.
another matter. That is another matter. You are saying this notification says beyond 1 year panel will not be valid. But this is not a case where the panel has been operated beyond 1 year. Let's stick
No,
to that.
and in that
If you have other arguments, you make
No,
it.
in that case, perhaps your lordship, I'll have to make an argument that whether after advertisement of one post and appointment having been made to that post, this panel can be operated for future vacancies. Perhaps that argument then in that case I'll have to make. My submission will be once the panel is exhausted after making the appointment, it cannot be operated for future vacancies.
That is correct, but Mr. Datta, I think I have not been able to make myself clear. I am asking you to substantiate your argument. You are saying this, that could be your opinion. But for the court to accept it, there has to be something to substantiate. The circular you have just relied upon does not even remotely substantiate your argument on that. It says the idea here is very simple, that very old and outdated panels are being operated to fill up vacancies. It is nothing to do with whether number of vacancies advertised should be filled up or not advertised should be filled up. This circular, as I have understood, only says ordinarily beyond 1 year, don't operate a panel. That's all. So that's correct. If that is your submission, we accept it. But in this case, the panel has not been operated beyond 1 year. So how does that got to do anything with your argument?
No, but why I say that it has been operated beyond 1 year, because after he was offered appointment on 29th of June 2011, this appointment was cancelled in the month of July 2011 itself.
Correct.
Thereafter, it has been revived again in the year 2013.
That's right.
So therefore, ultimately by trying to revive the panel in the year 2013, they are making a revival of a panel which expired 1 year, 2 years back.
They have only withdrawn the order of cancellation. Right. See, on that count, let's be very, you may like to project it that way, that we understand, but the offer was made within 1 year.
Yes.
They cancelled it and then withdrew the order of cancellation. That is another matter. But the offer was made and he was offered the appointment within 1 year of the validity of the panel.
Yes, on that point, there is no dispute. It was made within 1 year of the panel. Then, therefore, my lord.
That's the point here.
Yes, therefore, my lord, ultimately, it boils down to two aspects. First of all,
Mr. Kyle, as we interact with Mr. Datta, you show us that part of the record which conclusively establishes that there was 2 posts of deputy director vacant on the date. That will have a clinching bearing in this matter. I'm making it very clear. Because you can't go beyond, do anything beyond your rules. Yes.
So therefore, my lord, it will boil down to only 2 aspects in my humble submission. Number 1, whether the post to which he was appointed was at all available on that particular day. Yes, that is one aspect. And secondly, if it was really available, whether by way of operating this panel after the vacancy was filled up, it could be given for a second chance, for a second term. That is the case. Now, if he finds it out.
Have you finished?
No, the judgment that another point that both of them have raised, my lord, I think, my lord, it will be my responsibility to point it out. They have both taken a plea of delay and laches in filing the writ petition.
Right.
Now, in support of the explanation that has been given in the case, after this 2013 revival order came, representations were filed, but those representations were not given due consideration, and therefore a case was filed. One of the candidates who were aspiring for the appointment to this post.
You filed this in 2018.
18.
That is after.
Right. From 2011, it will be 7 years. From 2011, it will be 7 years.
What is your explanation?
Now, explanation is this, my lord. After this, the representations were disposed of in the year 2014. After the revival order came in 2013, because the moment within a month they cancelled the order, so everyone were at peace. Now, after 2 years when this was revived, then representations were filed. And thereafter, my lord, the representations got disposed of sometimes in the year 2014-15. And one of the candidates, my lord, he had instituted a petition before Honorable Madras High Court because he was posted there. So it was being fought at that particular court. Unfortunately, he expired in the year 2016-17. Thereafter, this petition was filed here.
No, but what has his writ petition got to do with your case?
No, the issue was same.
How can you enforce your right through somebody else's writ petition?
No, issue is same. Whether it could be.
No, Mr. Datta, you see, if issue is the matter, then we'll keep it alive to be decided in an appropriate case. The question is your client not seeking enforcement of his right here?
Of course.
Then was he waiting for someone else to
So
succeed?
that, my lord, I am just placing the facts, my lord. I don't want to.
No, that's
because
I didn't notice this.
I don't want to mean that
I did not notice that this was filed in 2018.
it was 2018.
That will have a bearing.
If it is counted from the.
Because you see, you're seeking an order of quashing his promotion.
Yes.
Please show us the explanation because that will have a relevant.
This is the explanation, my lord. I can just read it out from the paragraphs, my lord, in the.
Which paragraph?
In page 88, in the writ petition also, your lordship, these facts have been stated. And
Which paragraph in the writ petition?
Yes, my lord, I'm just making a reference of it. In page 88, that will be perhaps in page 90 in your lordship's brief.
That is in your reply.
Because
It was not explained in the writ petition.
No, they took the plea in the affidavit in opposition, so it was explained there.
Page number?
Page number 88, it will be 90 perhaps in your lordship's brief.
Yes. Internal page number 9, is it, Mr. Datta?
Will be definitely. Internal will be 9, yes. The second paragraph. As regards the statements. As regards the statements made in the paragraph 3L and 3M of the affidavit in opposition, the deponent begs to submit that one of his senior colleagues, so-and-so, the then assistant director, having the same grievance, preferred a writ petition before Honorable Madras High Court, challenging legality and validity of the respondent number 5, which was registered as WPC number so-and-so. Present petitioner and some other similarly situated assistant directors of so-and-so, all of whom
No,
were.
1 minute, you are reading from paragraph number?
It will be, it is this subparagraph of.
Subparagraph of paragraph?
Paragraph 5, but it extends to page 88.
Paragraph 5.
It will be 90 perhaps in your lordship's brief.
No. Can you give the internal page number of the affidavit?
That will be.
That could be paragraph
7, internal 7.
Yes.
Subparagraph as regards the statement.
Right, I got it.
Yes, the present petitioner and Summers so-and-so. The petitioner was therefore legitimately expecting that his grievance would be redressed if the said petition was decided by the Honorable Court. But due to sudden unfortunate death of so-and-so.
No, how can his
that is the explanation put forth. The sufficiency of it is.
No, that's no explanation. I'm so sorry. You can argue on this. This point will be seriously pressed against you, your client. Somebody else filing, I'm fence sitting, my grievance will be redressed in that. He died and then I have come that.
Ultimately, just now.
Is he not seeking enforcement of his personal right?
In the previous case, forenoon, my lordship friend was
do you
making the same argument.
Mr. Datta, do you seriously propose to argue that if the other man had succeeded?
On the delay and latches applicable where a case of.
The other person who
explanation must bear some relation.
Yes.
You see, I'm not on the delay, I'm on the explanation.
Yes.
Yes.
This explanation, are you really supporting this?
My lord, this way or that way, my lord, this is the only explanation that has come on record. Beyond this, there is no explanation. So it is the merit of this explanation, the probability of this explanation that your lordship will have to consider kindly. Ultimately,
No, you see, this is important because these are all fortuitous circumstances. But he was fence sitting. That shows that he himself
No.
was not.
no, he was, my lord,
How did he gain? Supposing that man succeeded in the writ petition, how would he have gained? How could he have enforced his right in that matter? Just give an example.
Yes, sir.
No, we have to test your explanation. You've given an explanation. The court cannot simply throw it away. Let us test it. If the other person, what his name is?
Jagdish Prasad.
Jagdish Prasad, had he succeeded in the writ petition filed before Madras High Court, then in that case, his appointment would have been set aside.
Yes.
Correct. And Jagdish Prasad would have been considered along with others for filling up that vacancy promotion.
Yes. Yes.
Right.
That is
So
precisely.
therefore, the idea is to get his appointment quashed. That's
Yes.
why.
Yes.
Nothing else.
That is also my
So
prayer.
that
in the
is a
writ petition.
personal rivalry. Why should the writ court get involved in that? That's a personal rivalry. As long as somebody is chasing him, fine.
My lord,
Let him not get away with the
my lord, the
promotion.
petitioner, in my respectful submission, my lord, petitioner cannot be branded plainly as fence sitter because he was also pursuing his cause before the authorities. He submitted representations. In the first round of representation, my lord, it was considered and his appointment was withdrawn. When it was revived, then also he also again filed representations. 2 of the representations are available on record. The representations were decided in the year 2014. It is
So what is the post your client is holding today?
assistant director.
He has not become deputy director.
He has participated in a selection process now.
Hmm.
Results are not known.
Recently.
Last month probably or this month.
Also participated.
So is he likely to be promoted?
Yes, sir.
Huh?
Because now he is on deputation.
By when can you give the result outcome? We'll have it after week of 2.
Well, can I just come in? 2 minutes. Now my learned friend is trying to enforce his right as what? Why my appointment as a direct recruit or in the promoted cadre?
If his client
No, I'm coming, my lord.
if
Kindly
his
see, my
client
lord.
gets promoted, we'll close the matter. Why are you?
No, my lord. My lord, on that date, he was not eligible to be considered for promotion because he didn't have the qualifying service. So as far as he challenged me, my lord, as far as promotion aspect is concerned, out of question. My lord, look at the suppression of material fact in the writ petition. Has he disclosed that the writ petition was filed in Madras High Court? He has not. My lord, has he made any explanation in the writ petition why he came 5 years after for 2013 and 7 years, my lord, after 2011? By end of the day, my lord, there has to be some judicial discipline. My lord, Supreme Court has said normally the law is as many posts advertised. Normally, this likely should come to an end. But my lord, if there are vacancies which can be offered and select list is valid, Supreme Court in several cases has upheld, my lord. In fact, I have brought such decision. In AP Agarwal's case, that was the precise argument, relying on modern law. That 11 posts were advertised, 11 posts filled up, you cannot operate. Meanwhile, vacancies arose, my lord, appointment was given. I'm just giving that citation.
So anyway, Mr. Chaudhary,
Yes. So, my lord.
it's always a pleasure hearing your argument. But we'll defer it by 3 weeks and let him give us the outcome.
Yes.
If he gets promoted, he cannot have any grievances.
Yes.
Because you can't seek retrospective promotion.
And kindly see, my lord, my learned friend is trying to step into the shoes of that late Mr. Prasad and enforce his right. What is this, my lord?
One thing,
And that one oath.
No, one thing I'll clarify, my lord. It also missed my notice, my lord. In the writ petition itself, my lord, the explanation is there. Page 15, paragraph 12. It was mentioned in the writ petition itself that
Mr. Datta and Mr. Chaudhary, if your client is promoted as deputy director in this process, that is the end of this matter. Why are we wrecking our
I do
What
not
is
know,
that?
my lord, he can still come out with a claim for seniority. I do not know.
Where?
He may still come with a claim for
File a writ
seniority.
petition, but in this case, obviously, we will not give you that. If you are arguing this matter, we'll dismiss that claim here. You
No,
can't claim.
not on this.
How
writ
can you claim seniority with effect from that date?
No,
when
no, my
you
lord,
have
I'm
done?
just saying that he may stay, because the employees always have some sorts of grievance,
It's
one
better,
or the
no?
other.
He will come to you for another case.
But,
File it.
but that
Mr.
question, your
Chaudhary
lordship
will
will.
get busier.
My lord, that famous Assamese proverb, my lord, Nizar Nakati, Otini Jatra Bango. So Jagadish Pradhan is not there, I'll step in.
That is the only explanation
But that
is
he has
all.
come
That's
on
a bad
board.
explanation. That's a bad explanation. What do we do, Mr. You see what you want to do. We'll postpone it by 3 weeks as a fixed part matter. The next day, we hope and trust that this writ petition will be closed as infractions. Writing a judgment is not a problem, but then we'll have to go into very many aspects and do a fine tuning of law in our view, which is always subject to being tested. But when, as a writ court, when we pass a judgment, we have to keep the larger society's interest at large in our. So we'll have to examine his explanation. We'll also have to examine in what manner, where from you got that post. That we'll see. That we'll have to see. So therefore, if it is not necessary to write a judgment, fair enough. And other remedies, if he wants to, or if anybody wants to pursue, that is up to them. No case is perfect factually, so there will be, but we will have to give our own reasons.
If there is a failure of justice, is an abhorrent violation, then my lord. It's not that my lord
That's
took
right.
this, yes.
But we have to give our reasons,
Yes,
whichever way. And therefore, since the process has already begun, if he gets promoted, we are not asking you to promote him, but if he gets promoted, this writ petition is surely an infractious matter.
After within 3 weeks, I think it will be, because the process is already over. It is only pending at the level of finalization.
Yes. So take down, I had Mr. S. Datta Lanet, senior counsel for the petitioner. Also had Mr. S. C. Kyle Lanet, CGC appearing for the respondent numbers 1 and 2. 1 to 4, is it?
Yes.
1 to 4.
1 to 4. Who has produced the records in terms of the order dated 9/11/2023 passed by this court. Mr. K. N. Chaudhary, Lanet senior counsel, assisted by Ms. R.R. Kakati, has appeared on behalf of the respondent number 5. During the course of hearing of this writ petition, it transpired that the process of promoting fresh departmental candidates to the post of deputy director has already been concluded, and the petitioner is also one of the candidates. Full stop. Mr. Kyle submits that awaiting the outcome of the process, further hearing of this matter be adjourned for 3 weeks. The said submission made by Mr. Kyle appears to be reasonable and is likely to have a relevant bearing in the outcome of this proceeding. As such, on the request of learned CGC, this further hearing of this matter is deferred till 18th of December 2023. So as to enable him to obtain instruction.
So next is 18th is your lordship is taking up on 18th again.
Yes.
Okay.
If in the meantime, if your client's promotion gets notified, then you obtain instruction.
Yes.
Whether anything else. Of course, if there is any other grievance, you have to pursue it in a separate writ petition.
Appropriate proceeding.
That we can leave it open, but not here. And here, if you don't succeed, then you will press it. Then we'll consider on that day whether there were more than one vacancy available, and if so, what impact it will have on your delay latches. And because he is entitled to argue, because you are trying to cut
He has a formidable argument to make.
Yes. So
Kota rota.
Kota rota.
All right then.
Deeply.
Yes. Yes, these people have retired from service. They are getting pension. That's what his instruction
Lordship,
is.
I'm sorry at first, Lordship. I'm sorry I was not there in the
Right.
at the time. Lordship, here 2 petitions are here. In one of the petition, the Dharmeshwar Boru, item number 15, he's received, Lordship. Similarly situated, to that of the item number 16, Lordship. So, my Lordship, the order dated of this, in this matter.
Oh, your clients are in service or they've retired?
No, retired.
So he's saying they are receiving pension, that's all?
No, Lordship. item
Dharmeshwar
number-
Bora is receiving.
Yes.
Dharmeshwar Bora is receiving, but Bhanta Kumar Roy, Lordship, they have, in that case, Lordship, although we have, after being re-engagement and being retired, the instruction is not available in regard to receiving of pension in regard to Bhasanta Roy. Item number 6, but Dharmeshwar Bora is receiving pension, Lordship. The instruction I have.
Yes, Lordship. Dharmeshwar Boro, he is receiving pension. But the next item, item number 16, this is Basanta Kumar Roy.
So we'll close item 15?
Lordship, that may not be closed because this has got relevance with this, because similar matter.
Maybe, but what relief does he want?
No,
Dharmeshwar Bora, what relief he wants?
Dharmeshwar Boro, no, he has received.
We'll close it.
Yes, yes.
Other matter you obtain is.
Yes, I'll obtain the
What
instruction.
Mr. Yeah, Tahvildar Learned Counsel for the petitioner. It was item 15 only. We also heard Mr. CPS Burwa Learned government advocate Assam appearing for the state. Mr. CKS Burwa submits that the petitioner was not only reinstated in terms of the order of this court, but he has since retired from service and is also regularly receiving pension. If that be so, nothing further survives for adjudication in the writ petition. Mr. Tahvildar and counsel for the petitioner has also fairly agreed to the state proposition. In view of the above, this writ petition stands disposed of as infructuous. In item 16, Mr. Tahvildar, learned counsel for the petitioner, is present and submits that although his client has been reinstated, re-engaged pursuant to the order of this court and has since retired from service on attaining the age of superannuation, no pension has been paid to the petitioner till today. Mr. CKS Burwa, learned government advocate Assam, submits that a week's time is required to seek instruction as to whether pension is being paid to the petitioner, Bhasanta Kumar Roy, and if not, the reason for not doing so. On the request of Mr. CKS Burwa, this writ petition is directed to be listed again in the next week for hearing.
Most solicitors.
Yes. You find out what has happened. Normally, if the period is less than 20 years, then they'll take a plea. Then we'll have to see what is the language of the order.
Lordship, this is a special PIF scheme, Prevention of Infiltration of Foreigners. Under that scheme, the government in 2019 has taken out a notification wherein said that even after even the person who completes 10 years, below 20 years but above 10 years, he is also entitled for pro rata pension, Lordship. That has been.
There are several judgments in regard to that.
So you give him.
Yes, already I have given.
Find out.
Already I have given.
Obtain written instruction.